Hello. Hello, Court Hall 19 in the.
ಹೇಳಿ ಮೇಡಮ್, ನಮಸ್ಕಾರಮ್ಮ.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್, ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಹಲೋ.
ಎಸ್ ಮೇಡಮ್.
ಸರ್, ನಂದು ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಇದೆ ಅಲ್ವಾ?
ಕ್ಲಿಯರ್ ಇದೆ ಮೇಡಮ್, ಕ್ಲಿಯರ್ ಇದೆಯಮ್ಮ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಆಯ್ತಮ್ಮ.
ಸರ್, ವಾಯ್ಸ್ ಕೇಳ್ತಾ ಇಲ್ಲ
ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ, ಸ್ವಲ್ಪ ಲೋ ವಾಯ್ಸ್ ಇದೆ, ಬಟ್ ಕ್ಲಿಯರ್ ಆಗಿದೆ ವಾಯ್ಸ್ ಅಷ್ಟೇ.
ಹಾ.
ನಮಸ್ಕಾರ.
ನೋಡ್ತೀನಿ ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿರ್ತೀನಲ್ಲ. ಅಲ್ಲ ನೀವ್ ಹೇಳಿದ್ ನಾನು ಒಪ್ಕೊಳ್ತಾರೆ ಇರ್ಬೋದು. ನೋಡ್ತೀನಿ ನಾನು ನೋಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೇಳಿ, ಫೈಲ್ ತೆಗೆದು ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ. ಪ್ರದೀಪ್ ಒಂದ್ಸಲ ಕಾಮನ್ ಮಾಡಿ. ಅವ್ರು ಮೂವ್ ಮಾಡಿದ್ರೆ ಹೇಳಿ ತಿಳಿಸ, ಅವ್ರು ತಿಳಿಸ. ನೋಡ ಇರ್ರಿ ನೋಡ. ಆಮೇಲೆ ಹಾಕಕ್ ಬಿಡ್ತೀನಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ನೋಡ ಇರ್ರಿ. You should have made a mention the other day. I would have passed an order fixing the date once again. You are going to give them so much of trouble, then. No, they will not respect us if we keep adjourning the cases.
My lord, serial number 46, my lord.
Yes.
So, in 46.1, I appear for respondent number 1. Sorry, respondent number 2 and a connected matter for respondent number 2, my lords. My lords, in
Yes.
first matter, I have not been served with the copy of the appeal memo, my lords.
Whom we
And the
appear
last-
for? Owner or for the claimant?
I am for the owner, my lords.
Wait, let us see. Wait.
Please, my lords, please, my lords.
Other? Adjourn more than one occasion, isn't it? Respondent, huh? You want time to file objections. Next. Ms. Pradeep. As requested, notice to R1 is dispensed with. Who's R1 and R2? Stand. Requested, this R1 dispensed.
serial number 3 ಮೇಲೆ
Dispense ಮಾಡಿದೆ.
ಇಲ್ಲ ನಾನು ಇಟ್ ಮೇ ಬಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್, ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಸಿಂಪಲ್ ಇದೆ ಮ್ಯಾಟರ್.
ಪ್ರದೀಪ್ ಇಲ್ಲ.
ಓ ಹಂಗಾರೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ, ಅಲ್ಲಿಗೆ ನವೆಂಬರ್ ಕೊಟ್ಬಿಡ್ತದೆ ಕಂಪ್ಯೂಟರ್.
Date. 20th.
My lords, serial number 4, my lord. My lords, the appellant, I beg to appear for the appellant, my lord. My lords, the appellant, my lords, has not deposited, my lords, the amount, my lords, as per the order of this honorable court. On the last occasion, I had sought time, my lords. However, there is no instruction, my lords, from the appellant also, my lord.
On 6th of December 2017. Notice and stay as paid for was granted subject to the appellant depositing the entire compensation amount within 4 weeks. Over the award amount has not been deposited as directed. Each time is with the condition deposit the entire compensation. It was made clear that if the award amount was not deposited, the appeal would be dismissed and not prosecuted. Till today, the entire compensation amount as ordered earlier has not been deposited. The appeal is not prosecuted.
My lords, a sum of rupees 25,000 statutory deposit was made, my lords.
We transferred to the tribunal.
My lords, please.
Some of the statutory deposit made shall stand transferred to the tribunal for disbursement. The claim is-
Public.
My lord, I appear for the appellant. 2 days may kindly be granted, my lord. Sub-service application is ready.
Who's
I
that?
file it, my lord.
Who's
My
that?
lord, I brought to my lord's notice last week. What was the vehicle, my lord? I brought to my lord's notice that it's a case of fraud, and that is how the matter was adjourned. 2 days I'll file my notice. Public.
Paper notification meetings for a part is accepted. The call date is absent. It's expired. Then I1 for modification. Modification.
Malaj, it seems like we have filed that application. Malaj, I'm not finding that application. Interim order modification again. Malaj, on 24/2/2022, Malaj, IA filed for deposit before MACT was accepted. On 24/2/2022. ಅಥವಾ ನಾನು ಹಂಗೆ ಬರ್ಕೊಂಡಿದ್ದೀನಿ.
ಅದೇನೋ ಇವನು ಸ್ಟೇ ತಗೊಂಡು ಆಮೇಲೆ ಅಲ್ಲಿ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಇದು ಅಂತ ಪೂರ್ತಿ ಕಾಸು ಡಿಪಾಸಿಟ್ ಮಾಡಿದಾರೆ.
ಹೌದು ಹೌದು.
So what do you want?
ಅಲ್ಲ ಮಾಡಿಫಿಕೇಶನ್ ಅಷ್ಟೇ ಆರ್ಡರ್ದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ದು. I have not deposited before this court as per the order ಅಲ್ವಾ, ಅಲ್ಲಿ 100% ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ.
12/2017. An interim stay of the interim award was granted subject to the insurer depositing 50% of the award amount. An application is filed stating that claimant had filed an execution petition and had obtained an attachment warrant. And as a consequence, the insurer has deposited the entire award amount of rupees 5,87,466. And in view of this deposit, the interim order will be suitably modified. Since the entire amount has been deposited, there will be no need to deposit for the executing court. No deposit will be made as per the order. Ready na?
TCR may be called for Malaj. Next week I will argue the matter.
ಏನು TCR ಬೇಕಾ?
ಹೌದು, ಇದು ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ವೆಹಿಕಲ್ ನ ಕ್ವಶನ್ ಮಾಡಿದೀವಿ.
You have the records with you. Next week. Today 18 days in filing is controlled. ಯಾರು? Paper publication R1 is accepted. R1 is called out. Mentioned in his place expired. User state in I1%. They have 127 days in filing the appeal is controlled. Ready na? Notice for R1 discussed. ಶಾಸ್ತ್ರಿಗಳೇ,
My lord, in the serial number 8, my lord, my name may be deleted, my lord. I am not appearing.
since KV9 because of BC presented up there. Must be both cases. Respondent ಯಾರು? Vivo Mahesh is there to take notice for the second respondent. This to R1 dispatched. Connected. First one on the right, second one on the dispatch. That is Vivo Mahesh. Is taken paper application that R1 is accepted. Ready na? ಇದೇನಿದು R5 ಯಾರು ಡಿಸ್ಕಸ್ ಮಾಡ್ಬೋದಾ ವೆಂಕಟೇಶ್ ಅವರೇ?
Yes, my lord, I am appearing for this. If it is serial number 12, my lord.
ಹೌದು.
ಸ್ವಾಮಿ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ. R5 ಸ್ಟೆಪ್ಸ್ ತಗೋತೀನಿ ಮೈ ಲಾರ್ಡ್.
ಇಲ್ಲ ಡ್ರೈವರ್ ಅಂತ ಏನ್ ಬೇಕಿಲ್ಲ ಅಂತಾರೆ.
ಡ್ರೈವರ್ ಅಲ್ಲ, ಓನರ್ ಸ್ವಾಮಿ ಇವರು. R5
ಡ್ರೈವರ್ ಅಂತ ನೋಡಿ ಚೆಕ್ ಮಾಡಿ.
1 week ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ, ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ಐ ವಿಲ್.
ಕ್ವಾಂಟಮ್ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಅಂತ ಇವನವ್ರು ಹಾಕ್ಬೇಕು. ಏನ್ ಕವರ್ಡ್ ಅಂತಲ್ಲ
ಅಲ್ಲ, ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅದು ಅವ್ರದ್ದು ಗಿರೀಶ್ದು ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಕೋರ್ಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿದೆ, ವಕಾಲತ್ ಸಿಗ್ನೇಚರ್ ಡಿಫ್ರೆಂಟ್ ಇದೆ, ಅದು ನೋಡ್ಬಿಟ್ಟು.
ಅಲ್ಲ ಕೇಸ್ ಏನಿಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನ ಕಡೆ ಇದ್ ಮಾಡೋಣ.
ಅಲ್ಲ, ಥರ್ಡ್ ಟೈಮ್ ಬಂದಿದೆ, ಒಂದ್ಸಲ 1 week ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ಬಿಡಿ. ಐ ವಿಲ್ ಆಲ್ಸೋ ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್.
Submits that the wakalat filed on permitted. Who's R1? Secretary notice to R1 is dispensed. ಮಹೇಶ್ ಅವರೇ? serial number 13. ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಏನೋ ನಿಮ್ಗೆ ಕೇಳಿದ್ರಂತೆ, ಹೋದ್ಸಲ ಕೊಟ್ಟಿದಾರಂತ.
ಅಲ್ಲ, ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, PCR ಅಷ್ಟು
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. I sent the papers to the company for verification. ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೀವೇನು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ, ಅದನ್ನು ಚೆಕ್ ಮಾಡ್ಬೇಕು, ನಾನು ಚೆಕ್ ಮಾಡ್ಬೇಕು.
ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ರಂತೆ ನೀವು?
ಸರಿ, ಅವ್ರು ಹೇಳಿದೆ ಸರಿ, ಪರವಾಗಿಲ್ಲ. ಅಲ್ಲ, ನನಗೇನು ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳಿ.
ಏನಾಗಿದೆ?
TCR may be called for more. Copies have been served on me. I have sent it to the company for verification.
ಏನಾಗಿದೆ? Bony amputation. How old was he? ಕಮ್ಮಿ ಆಯ್ತಲ್ವಾ ಮಹೇಶ್ ಅವರೇ ಡಿಸಬಿಲಿಟಿ
Pardon?
amputation above the knee.
Above the knee, according to the WC, part 1, it will be 60%.
60%.
Below knee is 50%. Above knee is 60%.
Any evidence here that he lost his job and then is there any evidence?
Doctor evidence, so CW1, my lord, doctor.
He has also suffered loss of physical function of the right upper limb ಅಂತ ಇದೆ.
ಇದು judgment ಅಲ್ಲಿ
para 25 ನೋಡಿ.
Page 25, para 25. In support of the contention, CW1 was produced the exhibit C1 disability certificate issued by CW1 doctor dated 7/12/2015. It is mentioned that disability certificate that the petitioner requires knee prosthesis and which require frequent change on account of wear and tear. That is the artificial limb. However, the doctor has not assessed the percentage of disability to the whole body. In the cross-examination, CW1 denied the assertion that the petitioner had not sustained disability to the extent of 86% of physical impairment and loss of physical function in the right upper limb. He had issued the disability certificate to the petitioner as per the guidelines of the Central Gazette notification. That's the 26.
I take it as 70% because he has also suffered a deformity to the right wrist. He can't really work after this, isn't he?
26 para 26 ಅಲ್ಲಿ ಅದು 1/3 ಇದು ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು 28% ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ತಪ್ಪಾಗತ್ತಲ್ಲ, ಅವನ್ ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾನೆ? ಫಂಕ್ಷನ್ ಡಿಸಬಿಲಿಟಿ ಅವ್ನ್ ಕಾಲಿಲ್ಲ ಅಂದ್ರೆ. He was a forest guard according to him. What job will he get?
And I don't have the full papers, Lord. That's why LCR, PCR may be quite far.
I have the records with me. I take it as 70% and close it.
Copies has been given to me. I have sent it to the company for verification.
The evidence on is the treated doctor. He says 86% to the right upper limb. Forest guard, why do you want me to adjourn this unnecessary?
28% is not proper, Lord. That's what I am saying.
70% ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ, 70% ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ.
60 ಆಗುತ್ತೆ, as per WC Act 60 ಆಗುತ್ತೆ.
ಕೈಗೂ ಏನೋ ಏಟ್ ಆಗಿದೆ, ಅದಕ್ಕೆ 70% ಮಾಡೋಣ. 70%. You'll get future prospects and you'll get, isn't it? You'll be able to do some work. ಎಷ್ಟಿದೆ? ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಎಷ್ಟಾಗಿದೆ? ಎಲ್ಲಿದೆ ಇನ್ವಾಯ್ಸ್?
Medical expenses 4,16,020 has been granted. Future medical expenses, my lord, 3 lakhs has been granted. That is, my lord, artificial limb.
But medical expenses 4,16,000, you are asking for But have you purchased it? Have you spent that money? What does the tribunal say about this in the order? The 37. You ಕೇಳಿದ 25 ಸಾವಿರ ಅಂತಂದ್ರೆ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಮಹೇಶ್ ಅವರೇ ನೀಗೆ ಪ್ರಾಸ್ಪೆಕ್ಟಸ್?
Future prospectus, no?
Because you now needs even according to Dr. Aboni prosthesis which requires frequent change on account of wear and tear. Yes,
No,
produced
there is no my lord, treatment. It is only the artificial limb, my lord, which has to be changed.
correct.
That's
How much do they? Now he has produced an invoice for 3,25,000.
That's why, my lord, I have sent it to the company for verification. Already, my lord, 4,16,000 has been granted. 3 lakhs for future medical expenses has been granted.
ಏನಿದೆ? ನಾರ್ಮಲಿ ಎಷ್ಟು ಕೊಡ್ತಾರೆ ಇಲ್ಲಿ ಪ್ರಾಸೆಸಸ್ಗೆ ನಿಮ್ ಪ್ರಕಾರ?
Lord, according to my lord, this thing is 1,25,000 is there. It has to be changed, my lord, once in 10 years. Because
2.5 lakhs. So I'll
Already.
grant him 2.5 lakhs.
he is an adult. If he is a young children, my lord, when the body grows, my lord, it requires frequent changing. But not in an adult, my lord. That will be 10 years. Once in 10 years, it has to be changed. If it is service, my lord, then there is no problem. It depends upon how he keeps it, maintains it.
ಆ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲಿ ಇಲ್ವಲ್ಲ? ಎವಿಡೆನ್ಸ್ ಬರೀ 3,25,000. We should be careful there. Only then we can do something here. You come with this bill, I can only grant this bill. How can I go above the bill? Somebody should talk about it. ಎಷ್ಟು ಏನು ಅಂತ ಹೇಳಿಲ್ಲ ಅಷ್ಟು. ಈ ಡಾಕ್ಟರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಸಿದ್ರೆ the accident which occurred on
19/8/2014,
which the claimant suffered grievous injuries which ultimately resulted in the patient who is not in dispute. The fact that the insurer is able to satisfy the compensation is also not in dispute. The tribunal, on assessment of the evidence, has awarded the following sums. The tribunal, despite taking note of the fact that the doctor had stated that the claimant had suffered 86% of physical impairment and loss of physical function right upper limb, has nevertheless concluded that claimant has suffered a functional disability of only 28%. Some record indicates that the claimant was working as a daily wager in the forest department. If a daily wager in the forest department loses an entire leg, virtually an entire leg, the functional disability would have to be definitely more than 28%. Because the probability of him securing another job or retaining the other job, retaining the present job, would be extremely unlikely. And therefore, of the view that the interest of justice will be served if the functional disability of the claimant is taken at 70%. The contended that he was working as a daily wager. However, no credible evidence was produced to indicate his actual income. The claimant has taken the income mostly at rupees 9,000 fixed by KSLSA. Disability, future prospects of 25% that will be added to the set income, which would result in a monthly income to be. As a consequence, the claimant will be entitled to some more rupees to 16 to 70% towards loss of future income. The tribunal has awarded some rupees 4,16,020 towards medical expenses. This award being based on documentary evidence is a fact. Yesterday in the hospital, the tribunal has awarded rupees 6,600 towards attendance and conveyance charges. The tribunal was hospitalized for, according to the evidence on record, that would matter to be appropriate to award a sum of rupees 60,000 towards attendant and conveyance charges. The tribunal has awarded a sum of rupees 3 lakhs towards future medical expenses. The evidence on record indicates that the prosthesis which the claimant requires would have to be maintained every year, every other year, and this would in turn result in further expenditure. And therefore, we would be appropriate to enhance future medical expenses from 3 lakhs to 4 lakhs. The tribunal has awarded some rupees 25,000 towards pain and suffering and rupees 50,000 towards loss of future amenities. And with regard to the fact that the claimant has lost his leg, both right knee, and is hospitalized for almost 2 months, it would be appropriate to award a sum of rupees 1,50,000 towards pain and suffering and rupees 1,50,000 towards future amenities. Tribunal has not awarded any sum towards loss of income in the later period. Since the claimant was hospitalized for 2 months, it would be appropriate to spend the later period of 6 months and award a sum of rupees 9,506. Accordingly, is to R1 is his mention.
My lord, I am appearing for the appellant insurance company, my lord. Appealed by the insurer, case of injury, my lord. So only on quantum, but I have to serve R1 and R2 second time PF bandide.
R1 ಯಾರು?
R1 claimant, my lord.
Raju, ನೀವು appear ಆಗ್ತಿರಲ್ಲ? Yes, Raju accepts notice for R1. For appeal. Appeal number ಯಾವ್ದು ನಿಮ್ಮ ಹತ್ರ ಇರೋದು? ಅವ್ರದ್ದು?
ನಮ್ದು 76-77 of 18, my lord.
Since the second respondent is served in the company on appeal, notice to him is held sufficient. ಏನು ಕೇಸ್ ಏನು?
Quantum matra, my lord. ಇದು 24% Dr. PW2, they have examined Dr. Manjunath, who said that 24% to right lower limb ಇದೆ. Page para 13 page number 7 ಬನ್ನಿ, my lord. Page 7 MACT ಇದು para number 13. Shall I read, my lord?
ಒಂದು ನಿಮಿಷ.
ಸರಿ ಸರ್.
para 13
para 13 page number 7 typed page 7. PW Dr. Manju Jaram has deposed that petition was admitted on 10/2/2016 with history of RTA. That the petitioner has sustained injuries, severe pain in the right leg, swelling present and deformity present, not able to move right lower limb, X-ray of right leg app, and lateral was taken and fracture of tibia right leg was confirmed. On 11/2/16, close reduction and tense nailing was done under GA. Discharged on 18/2/16. She has assessed the disability of the petitioner in suffering from physical impairment of 24% to the right lower limb. ಅದೊಂದೇ ಒಂದು ಇಶ್ಯೂ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್, my lord. 8% ತಗೊಳ್ಳೋ ಬದಲಿಗೆ ಲರ್ನೆಡ್ ಜಡ್ಜ್ 24% ತಗೊಂಡ್ಬಿಡ್ತಾರೆ. ಕಮ್ ಟು ನೆಕ್ಸ್ಟ್ ಪೇಜ್, my lord. para 16. 24% ತಗೊಂಡು 3 ಲಕ್ಷ ರೂಪಾಯಿ ಅವಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ಸುಮ್ಮನೆ ಅದೊಂದೇ ಕ್ವಶನ್ ಮಾಡಿದ್ವಿ ಕೋರ್ಟ್ ಮುಂದೆ.
ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ. PW2 evidence may kindly be taken, my lord. Cross examination, my lord. Page number 2 ನಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಚೀಫ್ ಗೆ ಬನ್ನಿ, ಸೆಕೆಂಡ್ ಪೇಜ್ ಬನ್ನಿ, my lord. ಥರ್ಡ್ 1 2 3 4th ಪೇಜ್ ನಲ್ಲಿ I am of the opinion that patient is suffering from physical impairment of 24% in respect of right lower limb. Doctor
ಶಾರ್ಟಿಂಗ್ ಏನಾರ ಆಗಿತ್ತಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೂಡ ಮಾಡಿದ್ದೀವಿ. ಇಲ್ಲ, ಶಾರ್ಟ್ನಿಂಗ್ ಏನು ಹೇಳಿಲ್ಲ, my lord. Either in the chief or in the cross. So 8% ತಗೊಳ್ಳೋ ಬದಲು ಜಡ್ಜ್ ಫೇಲ್ ಟು ಟೇಕ್ ಇಟ್ ಎಂಟೈರ್ 24% ತಗೊಂಡು ಅಬೌವ್ 10% ಅಂತ ಹೇಳಿ 3 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ತಾರೆ. ದಟ್ಸ್ ಓನ್ಲಿ ಕ್ವಶನ್ ಬಿಫೋರ್. ಫರ್ದರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕೂಡ 43,000 ಆಗಿದ್ರೆ 55,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ದ ಬಿಲ್ಸ್ ಟೋಟಲಿಂಗ್ ಹಾಸ್ಪಿಟಲ್ 8 days inpatient. ಡಾಕ್ಟರ್ ಲಿಂಗೇಗೌಡ ಹಾಸ್ಪಿಟಲ್, ಅವ್ರ ಲಿಂಗೇಗೌಡ ಹಾಸ್ಪಿಟಲ್ ಡಾಕ್ಟ್ರೇ ಸ್ವಾಮಿ ಜಯರಾಮ್ ಅವರು.
Interesting.
What is this P14?
ಅಲ್ಲ 11 and 12 ಕ್ಲೋಸ್ ಆಗುತ್ತೆ. 11 and 12 ನೋಟರೈಸ್ ಕಾಪೀಸ್ ಆಫ್ ಆಧಾರ್ ಕಾರ್ಡ್ಸ್ ಅಷ್ಟೇ. 14 ಇಲ್ಲ, my lord.
P14 ಅಂತ ಇದೆ ಇಲ್ಲಿ.
ಅಲ್ಲ, ಬೈ ಓವರ್ಸೈಟ್ ಎಲ್ಲ ಬಂದಿದ್ದಾರೆ. ಮಾರ್ಕೆಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದು ಒಂದು 11 to P1 to 2.
ಕೆ ಶೀಟ್ ಅನ್ನು P13, ಡಿಸಬಿಲಿಟಿ ಫಾರ್ಮ್ ಪ್ರೊಫಾರ್ಮವನ್ನು ಎಕ್ಸಿಬಿಟ್ P14, ಇತ್ತೀಚಿನ OPD ಸ್ಲಿಪ್
that was not marked, my lord. P12 ಅಂತ ಪೇಜ್ ನಂಬರ್ 14 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಲರ್ನೆಡ್ ಜಡ್ಜ್.
10% ಅಂದ್ರೆ 3 ಲಕ್ಷ ಬರುತ್ತಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಬಿಲೋ 10% ಆದ್ರೆ 10% ಆದ್ರೆ my lord, kindly come to ಲರ್ನೆಡ್ ಜಡ್ಜ್ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
ಇಲ್ಲ, ಮಲ್ಲಿಕಾರ್ಜುನ್ ಕೇಸ್ 10% ತಗೋಬೋದಲ್ಲ, 8% ತಗೋಬೇಕು ಅಂತ ನೀವು.
ಪ್ಯಾರಾ 16 ತಗೊಳ್ಳಿ my lord. ಪ್ಯಾರಾ 17, page number 9. Last 2 lines ಮರ. For permanent disability up to 10%, it should be 1 lakh.
ಆಯ್ತು, ನಿಮ್ದೇನು?
Page number 9, ಪ್ಯಾರಾ 17.
ಹೋಲ್ ಬಾಡಿಗೆ ಏನಿಲ್ಲ, ಬರೀ ರೈಟ್ ಲೋವರ್ ಲಿಮ್ ಅಂತ ಇದೆ.
ಹೌದು ಸ್ವಾಮಿ.
I'll maintain the award at 3 lakhs.
ಅಯ್ಯೋ ಜಾಸ್ತಿ ಆಗುತ್ತೆ my lord. ಯಾಕೆ ಅಂತಂದ್ರೆ ಇದರಲ್ಲಿ ನಾವು ಜಾಸ್ತಿ ಅಂತ ಯಾಕೆ ಅಂತಂದ್ರೆ as per decision by the Honorable Supreme Court, Master Mallikarjuna ಕೇಸಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 17 ತಗೊಂಡು ಪೇಜ್ ನಂಬರ್ 9 ನೋಡಿ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ 3 ಲೈನ್.
I will hold that 24% the right lower limb ಅಂತ ಅಂದ್ರೆ it is more than 10% ಅಂತ I will hold whole body.
ಅಲ್ಲ 8% ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಇವನ್ ಟೇಕಿಂಗ್ ಇಟ್ ಆಸ್ ಪರ್ ಡಾಕ್ಟರ್ 24% ಅಂದ್ರೆ limb disability ಗೆ it comes to 1/3, 8% ಆಗುತ್ತೆ. So that comes to below 10% only.
In hospital ಎಷ್ಟು ದಿನ? In respect of an accident which is not in dispute and the liability of the insurance company to satisfy the compensation of the dispute, the tribunal has awarded a sum of rupees 3,56,800. Both the insurer as well as the claimant are agree. The insurer contends that the medical evidence on record indicates that the claimant had suffered 24% impairment to the right lower limb, and therefore the whole body disability will have to be taken at 8%. However, learned counsel for the claimants contend that having regard to the fact that the claimant was a 10-year-old girl, the tribunal has rightly assessed the disability at 25% and awarded a sum of 3 lakhs as per the decision rendered in Master Mallikarjun's case. It is no doubt true that in normal circumstances, 1/3 of the disability assessed to a particular limb is taken as the disability to the whole body. However, that is not a hard and fast or a rigid rule. In my view, with regard to the fact that the claimant suffered a fracture of the tibia of the right leg, it would be appropriate to determine the permanent disability to be above 10%. With regard to the fact that the claimant was a 10-year-old girl, in this issue of the matter, the sum of 3 lakhs awarded towards pain and suffering, loss of amenities, etc., is just and proper and does not require any interference. The tribunal has awarded a sum of rupees 1,800 for loss of earnings to the parents during the period of hospitalization. The evidence on record indicates that the claimant was hospitalized for 9 days. Appropriate to award a sum of rupees 10,000 towards conveyance from food nourishment and loss of earnings to the parents for the period of hospitalization. The tribunal has awarded a sum of rupees 5,000 towards medical and incidental expenses. This sum being just and proper does not require any interference.
ಅದು ಎಕ್ಸೆಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. 43,000 ಬಿಲ್ಸ್ ಕೊಟ್ಟಿರೋದು, 12,000.
As a consequence, the claimant will be entitled to the following sums: 3 lakhs plus 10,000 plus 5,000. The appeal of the insurer is dismissed and the appeal of the claimant is allowed and granted.
Amount in deposit may be transferred. Please. Nice.
Who's R2? Dispense ಆಗಿದೆಯಲ್ಲ ಕನೆಕ್ಟ್ ಮ್ಯಾಟರ್. What bro? What is implicated? Whom did you examine? Try to secure the CR. Do it again. Ravi Samprati will take notice for. R1 yaru? B Pradeep and take notice for R1 as requested notice to R2 dispense with. Letter ತಾನೆ ಬಿಟ್ಟಲ್ವಾ next time is better to the number 18. Requested notice to R1 is dispensed with. Resulted in one bar. Next time. Sachin. ಬಾಕಿಲ್ವಾ 2 ಸಲ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ I can direct ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ನಾವು can direct the KAT to I'll ask him to be present, then he will take step. Next time if he does not do anything, I'll ask him to be present. Vijay Kumar.
D. Vijay Kumar.
In our appeal, ಯಾವ ground ಮೇಲೆ? Our appeal in ground. What ground have they filed in appeal? $33 days delay ಇದೆಯಾ ಕಂಪ್ಲೇಂಟ್ ಇಂಜುರಿ ಏನಾಗಿತ್ತು ಅವ್ರಿಗೆ reports ಬಂದಿದೆ. ಏನಿದ್ರು ಹಾಸ್ಪಿಟಲ್ ಅವರು ಎಷ್ಟು ದಿನ ಇದ್ರು ಆಕ್ಸಿಡೆಂಟ್ ಆದಾಗ್ಲಿಂದ ಎಷ್ಟು ದಿನ ಇದ್ರು ಕೆಂಪೇಗೌಡ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ? ಫಸ್ಟ್ ಅವ್ರು ಹೇಳೋದು 33 ದಿನ ಡಿಲೇ ಇದೆ ಅಂತ. ಸೊ ಫಸ್ಟ್ ಟೈಮ್ ಹಾಸ್ಪಿಟಲೈಸ್ ಆದಾಗ ಎಷ್ಟು ದಿನ ಇದ್ರು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ? ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ? ಡಿಸೀಸ್ ಸಮರಿ ಇದೆ ನಿಮ್ಮ ಹತ್ರ? ಎಕ್ಸಿಕ್ಯೂಟ್ P9 to P14 ಇದೆಯಾ?
with your lordship's kind leave,
Yes,
my lord, serial number 22, my lord.
yes.
My lord, can it be taken at 2:30, my lord? I'll come personally and argue the matter. Because vehicle is not involved in the accident.
2:30.
Much obliged. I'm sorry, my lord, I was in the other court.
Lords, I appear for the appellant insurance company.
In case. You have an application for withdrawal. On ground. Did the accident occur?
Lords, it was a head-on collision between two motorcycles.
You
Both
appear
the-
for second. Insured of?
Yes,
The vehicle in which he was traveling. Package policy. 7801 ನಿಮ್ದಾ?
780 ನಮ್ದು ಹೌದು.
The trial court has tribunal has taken you as responsible for the accident.
ಹೌದು sir. In fact, both of them have been charge sheeted by the police after investigation. There is no independent evidence by either of the parties.
The accident is not in dispute, death is not in dispute.
ಹೌದು.
Isn't it?
ಹೌದು.
So charge sheet even according to is on both of you.
ಹೌದು sir.
Then how can you escape liability?
Well, I am not trying to escape liability. I am only saying apportionment should be there on the deceased also. Swami, ಆಮೇಲೆ ಇನ್ನೊಂದು ಗ್ರೌಂಡ್ ಇದೆ ಇದರಲ್ಲಿ. ರೈಡರ್ ಯಾರಿದ್ದ ನಮ್ಮ ಇನ್ಶೂರ್ಡ್ ವೆಹಿಕಲ್ ಇನ ರೈಡರು ಅವನು ಗಾಡಿನ ಕಳ್ಳತನ ಮಾಡ್ತಾನೆ. ಕಳ್ಳತನ ಮಾಡಿ ಗಾಡಿ ತಗೊಂಡು ಹೋಗ್ಬೇಕಾದ್ರೆ he causes this accident.
The vehicle is insured. How does it matter?
ಒಂದು ನಿಮಿಷ ಅವನ ಹತ್ರ DL ಇರ್ಲಿಲ್ಲ.
So pay and recover, that is all, isn't it?
ಅಲ್ಲ, ಪೇ ಅಂಡ್ ರಿಕವರಿ ಅಂದ್ರೆ ಪಾಪ ಓನರ್ದು ತಪ್ಪಲ್ಲ. ಹಾಗಾಗಿ ನಂಗೆ ಏನ್ ಹೇಳ್ಬೇಕು ಗೊತ್ತಿಲ್ಲ. It is a unique situation. The owner is also not at fault. Owner did not hand over the vehicle to him. She had filed a complaint that the vehicle was stolen.
Then you'll have to take responsibility. What can you do if it is stolen? The stolen vehicle, if it is caused.
I am only appealing to the court. Could it be that the rider can be made liable to pay the compensation?
Oh, so you will ensure that he gets no compensation.
ಅಲ್ಲ ಯಾರು ರೈಡರ್ ಅಂದ್ರೆ ನಮ್ ಗಾಡಿ ರೈಡರು ಕಳ್ಳ.
ಸೊ ಕಳ್ಳನ ಮೇಲೆ ಹೋಗಿ ಕಾಸು ಇಸ್ಕೊಳಕ್ ಆಗಲ್ಲ, ಅದ್ರಿಂದ ಕಳ್ಳನ ಮೇಲೆ ಹಾಕೊಂತೀರಾ?
ಹಾಗಲ್ಲ. ಐ ಆಮ್ ಓನ್ಲಿ ಮೇಕಿಂಗ್ ಎ ಸಬ್ಮಿಷನ್ ಸ್ವಾಮಿ. ಇಟ್ ಇಸ್ ಎ ಯುನೀಕ್ ಸಿಚುವೇಶನ್.
Prove the theft.
ಸ್ವಾಮಿ,
did you prove the theft?
It is an undisputed fact. The tribunal has also accepted.
Did your insurer accept
ರಿಕವರಿನೇ ಮಾಡಿ ಸ್ವಾಮಿ, ಆಯ್ತು. ಇಲ್ಲಾಂದ್ರೆ ಪೇ ಅಂಡ್ ರಿಕವರಿನೇ ಆಗ್ಲಿ ಅಷ್ಟೇ.
ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್ ಅದರ ಮೇಲೆ?
ಸೆಕ್ಷನ್ 1 ಸ್ವಾಮಿ
ಎಲ್ಲಿದೆ? which paragraph is the discussion?
17.
Who is respond number 1? Ambikana. How are you saying that the thief did not have a license?
Police have charge sheeted him under section 181.
Also thought, no?
It is a unique situation. Hagagi, I am bringing all facts to the notice of the court.
We'll hold that obviously because he was a thief, he was trying to run away from the spot. He would be negligent. He would have been the cause for the accident.
ಅವಾಗ ಅವನ ಅಲ್ಲ, if there is a claim petition filed by him, then that gets rejected.
ಯಾರು?
ಇವಾಗ ಅವನ್ ಡೆತ್ಗೆ ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ ಬಂದಿದ್ರೆ then that claim
ಹಾಕಿದಾರಾ?
petition will get rejected.
ಅಲ್ಲ ಅವನ ಕಳ್ಳ ಅವ್ರು ಹಾಕಿದಾರ? ಹಾಕಿಲ್ವ ಅಂತಲ್ಲ ಬಿಡಿ.
ಆಯ್ತು. My contentions may be noted, Malaj, ಇದರಲ್ಲಿ.
A claim petition was filed by the legal heirs of Onkarappa, contending that while he was riding his motorcycle on 14th of July 2014, his motorcycle was hit by another motorcycle, which was being driven by one Nataraj Allah, which was being driven by one Charan. It was contended that he said Charan died at the spot. And who was this Nataraj? Nengada Onkarappa antadu. Avatu Nataraj. Then Nataraj, who was the owner of motorcycle wearing registration number K18 S8273, sustained grievous injuries and was shifted to an hospital at Chikmagalur and from there to an hospital at Shivamogga. But on the way to Shivamogga, he succumbed to his injuries. It was contended that the claimants, being the LRs, were entitled for compensation for the death of Nataraj. The owner of the motorcycle, which was being driven by Charan and was killed at the spot, entered appearance and contended that the motorcycle belonging to her was stolen and the accident had occurred within 20 minutes of the theft. She contended that she had lodged a complaint before the police and the investigation was in progress. She stated that the accident was not solely due to the rash and negligent act of driving on the part of Charan, and there was negligence on the part of the deceased Nataraj also. The insurer of both the motorcycles entered appearance and denied all the contentions raised by the claimants. The tribunal, on an assessment of the evidence adduced before it, has come to the conclusion that the claimants had proved that an accident did occur and which resulted in the death of Nataraj. And it also held that the insurer of motorcycle bearing number K18Q7801 that was driven by Charan was not holding an effective driving license at the time of the accident. The tribunal accordingly proceeded to pass an award holding that the claimants were entitled to a compensation of ₹7,85,000 and made the owner of the motorcycle bearing number K18Q7801 and its insurer jointly and severally liable. The insurer was directed to deposit the amount within 2 months. Being agreed by this award, the insurer of the motorcycle being driven by Charan is an appeal. The claimants are also in appeal seeking for enhancement. Learned counsel for the insurer of the motorcycle being driven by Charan contends that the police had laid a charge sheet against both Charan and the deceased Nataraj, and therefore apportioning negligence only on Charan was improper. It is also contended that since the police had charge sheeted Charan under section 181 of the Motor Vehicles Act, the insurer would not be liable for payment of compensation as there was a clear breach of policy conditions. Learned counsel for the claimants, however, contends that the mere filing of a charge sheet against both Nataraj and Charan would not indicate that Nataraj was at fault. He submits that in regard to the fact that the vehicle had been stolen and was obviously being driven away to escape the clutches of law, it will have to be presumed that the accident occurred due to this negligent act of the thief. He submits that the tribunal therefore was justified in casting liability on the insurer of the motorcycle which was being driven by Charan. In the light of the admitted fact that the motorcycle driven by Charan had been stolen, the presumption can be drawn that Charan was trying to flee from the spot, and in all probability, in this anxious state of mind, he caused this head-on collision, which resulted in the death of Nataraj, merely because the police charge sheeted both Nataraj and Charan. That would not by itself lead to an inference that Nataraj had contributed to the accident. The insurer did not produce any independent evidence indicating the negligence on the part of Nataraj, and the entire case was based only on the charge sheet. The absence of any positive evidence indicating negligence on the part of Nataraj, the insurer cannot contend that he had also contributed to the accident. It is settled law that mere filing of a charge sheet would not lead to an inference of negligence on the part of the accused, and the negligence would have to be independently proved before the tribunal. The tribunal in this case has taken note of the facts and has come to the conclusion that the accident occurred due to the fault of Charan, and therefore it has rightly fastened liability on the insurer of the motorcycle. Since it is contended that Charan did not have a driving license, the appropriate course of action for the insurer, that is the appellant herein, would be to pay the compensation and thereafter proceed to recover the same from the owner of the offending vehicle. It is to be stated here that there can be no case of pay and recovery in this case, since the owner of the vehicle did not hand over the vehicle voluntarily to Charan, and since the police complaint was lodged indicating the theft of the vehicle, the question of ordering pay and recovery would not arise. So, an order of pay and recovery would have to be passed only in cases where the owner of the vehicle was guilty of a breach of the policy conditions. If the owner had not handed over the vehicle to a person who did not have a license, then an argument could be advanced that there was a breach of a policy condition. If, however, the vehicle itself had been stolen by a person who did not possess a driving license, the owner cannot be fastened with the liability to pay compensation for a crime which has been committed on him. In my view, since the vehicle was insured, the liability of the insurer would have to be attracted, even if the vehicle had been stolen. Since the fundamental principle of insuring a motor vehicle is to ensure that any damage caused out of the use of a motorcycle is covered by the insurance company. The insurance company cannot exonerate itself on the ground that a crime had been committed and the criminal who had taken the motorcycle did not possess a driving license. In such cases, the insurer would have to satisfy the compensation and cannot even seek for pay and recovery. Consequently, it is held that the liability of the insurer would stand attractive, even if the insured vehicle has been stolen and the person who stole the vehicle did not possess a driving license. Consequently, the appeal of the insurance company is dismissed. As far as compensation is concerned, as compensation is concerned, the tribunal has taken the income of the deceased notionally at rupees 4,000. Evidence is there. Since there is no credible evidence to ascertain the actual income, it will be appropriate to drop the sum of rupees 8,500 returned by KSLSA for actions of the year 2014. As the deceased was 25 years, 40% would have to be added to the most income rupees 8,500. This would result in the monthly income to rupees 61. Out of this, 1/3 that will be deducted. 1/3 and this would result in the monthly income to rupees 61. Consequently, the claim will get to some of this. Multiplier is 16. 16 or 15. 35 or 36. 16. The claimants being the parents, wife and daughter. Each of them will entitled to a sum of rupees 44,000 towards loss of consortium. And a further sum of rupees 33,000 under the convention. As per the appeal of the claimants allowed in court.
Amount in deposit may be transmitted to the tribunal.
On the last occasion, I think it was your case or somebody else's case. Similar stolen vehicle, we had held that your liability will be covered.
ಇಲ್ಲ ನಮ್ದಲ್ಲ ಸರ್.
ಯಾರೋ ಒಬ್ಬರದು ಮಾಡಿದೆ. Last occasion, given this roster, there's already a decision that was based on some Supreme Court decision.
I am not aware.
I'll incorporate that also into this.
Amount in deposit may be transmitted to the tribunal.
After another. Right, yeah. Which paragraph?
Paragraph 11.
Yeah, paragraph.
No.
Picture of cornea, no?
Cornea and melon.
You've lost vision in the right eye completely? He does not have vision in one eye. He finished his course. Engineering ಮುಗಿಸಿದ್ರಾ? ಇದ್ದವ್ರೆ?
But he has completed his engineering. Which is also present to cosmetic appearance, it doesn't seem to be any affected. But thing is, my lord, the fracture of cornea is there. And my lord, he has taken the subsequent treatment also. The tribunal has already awarded my lord 11,82,600.
20% Saka. Or will you? What is his chances of being employed with one eye? Who will employ engineer with one eye? Will he get the same job as before? All the more reason.
And now, awareness are more. But future loss of further 18,000 rupees.
Which college was he studying in? Which college was he studying in? ಯಾವ ಕಾಲೇಜಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀವಿ? Which college was he studying in? ಯಾವ ಕಾಲೇಜು ಯಾವ ಸಬ್ಜೆಕ್ಟ್ ಹೇಳಿ? ಯಾವ ಕಾಲೇಜ್ ಯಾವ ಸಬ್ಜೆಕ್ಟ್ ಯಾವ ಕೋರ್ಸ್? ಮೆಕ್ಯಾನಿಕಲ್ ಇಂಜಿನಿಯರಿಂಗ್. ಯಾವ ಕಾಲೇಜು? ಮೆರಿಟ್ ಸೀಟ್ ಇರೋದು.
I am not saying that. But thing is, 13,000, sorry,
18,000 is on the lower side, is what I am thinking. If he has done his mechanical engineering.
He was at that time, present, I do not know whether they are selling in here.
What would be the salary for an engineer in the year 2013 in the government and in the private sector? We will take the average and calculate.
Already 11,87,000.
Forget about the figure. Figure is not that important.
already awarded, I think it has been progressive. The application was further consideration of requisites. That's all already without, but it can be remanded to the people.
What is the percentage of disability that I should take?
Right side,
Very close quarters, he can count his fingers on them.
That time one second. Don't amount is not better can be remanded.
40% functional disability, income ಎಷ್ಟು ಕೇಳಿ. So all right, what is the salary, the income I should take? ಅದನ್ನ ಹೇಳಿ sir.
Income the indication of income.
How much did he claim?
That is the 2013, 8,000 has been provided very legal service authority start 18,000, and then 18,000 has been considered. And now he has completed his engineering also.
He's married?
My humble submission is, if matter is remanded, so all aspects will be considered, even regarding medical expenses. So that whether it pertains to this injury or what, we do not know. Some doctors used to speak about that present condition. And if the matter is remanded, we will not have an opportunity whether he is employed.
ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಇವಾಗ 79,000.
If he is entitled for any amount after examination, regular will be decided.
My right eye and left eye has been fully damaged. The doctor said only right eye, isn't it? Why are you saying now right eye and left eye? ಎಲ್ಲಿದೆ ಅದು? Sixteen of? ಅಲ್ಲ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ರೈಟ್ ಲೆಫ್ಟ್ ಎರಡು ಹೇಳ್ತಿರಲ್ಲ, ಮುಂಚೆ ರೈಟ್ ಅಷ್ಟೇ ಇಲ್ಲ ಆಗಿದೆ ಆತರ. ಬರೀ ರೈಟ್ ಐ ಮಾತ್ರ ಅಷ್ಟೇ ಹೇಳಿರೋದಲ್ಲ. ಅಪ್ಲಿಕೇಶನ್ ರೈಟ್ ಲೆಫ್ಟ್ ಎರಡು ಹೇಳ್ತಿದ್ರ.
Paragraph 12 that doctor CH-19 he says that doctor of rice farming. So the interest of all parties can be remanded.
And what is the benefit?
Already.
So you just want to keep the litigation pending for 10 more years. He's been in court for 10 years. After the accident, you want him to be in the court for another 10 years. Remand ಅಂದ್ರೆ ಅಷ್ಟೇ ತಾನೆ.
But we was
ಹಾಗೆ. Are you disputing this evidence? Yes.
after the accident,
ಬರೀ ಬಿಲ್ಸ್ ಅಷ್ಟನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ನೀವು? ಬಿಲ್ಸ್ ಮಾತ್ರನಾ?
bills ಮಾಡಿದ್ರೆ and certain bills ಮಾಡಿ lot make idea ಇದೆ. I could not cannot ಇದೆಲ್ಲ ಇದೆಲ್ಲ fuel bills ಎಲ್ಲ petrol bills ಎಲ್ಲ ಕೊಡೋದು.
How many days was he admitted again? ಇನ್ಸಿಡೆಂಟ್ ಅಡ್ಮಿಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಅಲ್ವಾ? He has not been admitted. This is only review, that's all, every year. In review ಅಷ್ಟೇ ತಾನೆ? He has not been admitted or has not undertaken any other further ಏನ್ ಫರ್ದರ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಏನ್ ತಗೊಂಡಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ? What because the evidence that
that doesn't really defects or subsequent any weakness etc. You not know latest patient EMR summary.
there is no procedure that he has undergone afterwards. This is regular review every year or periodical review, that is all. He has not undertaken any procedures. Future medical expense ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಅವಾಗ? ₹50,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 71,000 ರೂಪಾಯಿ ಬಿಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ಆಲ್ಮೋಸ್ಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್. ಎಲ್ಲಿದೆ ಕೊಡಿ. The bills that you have produced totally indicate only 79,000. ಅದರಲ್ಲಿ 1,200 ರೂಪಾಯಿ ಬಸ್ ಟಿಕೆಟ್ ಅದು ಇದೆ. So roughly 50,000 granted is correct. See, if CW3 had said you require 1 lakh for repeated surgeries, what is the surgeries that you undertaken since 2013? For 10 years, you should have undergone some surgery. Where is the medical evidence to show that you underwent surgeries? ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ ಸರ್ಜರಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಪೇಜ್ ನಂಬರ್ 9 ತಗೊಳ್ಳಿ ಫಸ್ಟ್. Treatment, injection, capsules, tablet, Atorva. I will maintain that 20,000 and that 40% and close.
So, 2013, 8,000 is there.
Minimum wages 8,000.
Like other laborers are. No, not after the evidence. After the 6 days, he completed the engineer. So he will not be thrown qualified engineer. Will not remain like that.
But he will always have this handicap permanently.
But of that social income point, it is again.
And you accepted that 18,000 rupees. Therefore, if you yourself accept 18,000 rupees was justified. Therefore, you have accepted the assessment at 18,000 rupees. I am saying let it be 20,000 rupees. That is all.
Practical aspect
And loss of marriage prospects ಎಷ್ಟು ಕೊಡಬೇಕು? He has to tell his prospective bride that he does not have one eye. Respect of an accident which is not in dispute, and the liability to pay the compensation by the insurer is also not in dispute. The tribunal has awarded the following sums. Admittedly, as a result of the accident, the claimant has lost vision in his right eye The doctor was examined as CW3 as stated that the claimant had suffered 30% disability. The tribunal has, however, assessed the disability at 20% and has determined the income notionally at rupees 18,000. Third counsel for the claimant contended that the claimant was studying in the final year engineering, and as a result of the injury, his prospects of securing a good job has stood dramatically reduced. He submits that even if the claimant were to be employed, he would be not able to earn as much as a normal engineer would earn. He therefore submits that the functional disability and the loss of earning capacity together will be taken at 60%. He also submits that the claimant was studying in BMS college and had secured a seat on merit, and therefore determining his income at rupees 18,000 per month is on the lower side. See, SV Agdevolpan, on the other hand, contends that the tribunal has correctly assessed the disability at 20% and has in fact been generous in determining the monthly income at rupees 18,000. He submits that the tribunal award is just and reasonable and does not call for any interference. As noticed above, the claimant has admittedly lost vision in his right eye. And in regard to the fact that the claimant is a mechanical engineer, the loss of vision in one eye would have a definite impact on his earning capacity. Even though the doctor has stated that the disability would be to the extent of 30% to the whole body, in my view, it would be appropriate to determine the functional disability at 40%. The tribunal has determined the income of the claimant at rupees 18,000. In my view, in regard to the fact that the claimant was studying in the final year of mechanical engineering at BMS college, it would be appropriate to determine the notional income at rupees 20,000 per month. Consequently, the claimant will be entitled to some rupees 20,000 into 12 into 18 into 40% towards loss of future income. The tribunal has awarded a sum of rupees 75,000 towards pain and suffering. In my view, it would be appropriate to enhance the said sum to rupees 1 lakh. The tribunal has awarded a sum of rupees 25,000 towards loss of amenities. Since the claimant has lost the use of one eye, it would be appropriate to award a sum of rupees 1 lakh towards loss of amenity. The tribunal has awarded a sum of rupees 10,000 towards loss of marriage prospects. In my view, interest of justice is served if a sum of rupees 1 lakh is awarded towards loss of marriage prospects. The tribunal has awarded a sum of rupees 2,50,000 towards medical expenses, conveyance and diet, and a further sum of rupees 50,000 towards future medical expenses. In my view, these sums are just and proper and do not require any enhancement. Consequently, the payment will be entitled to the following sums. Where is this?
There was a delay for 56 days in filing the appeal, my lord. Along with the appeal, my lord, I had also produced, my lord, additional documents to show that, my lord, the driver had a valid license and, my lord,
Well, matter request to be amended because he remained ex parte before the tribunal. Now he has preferred an appeal with certain contentions which has to be proved.
Why was it fastened on the owner?
Driving license.
So, driving license idea.
He himself has given a statement, my lord, for reply under section 133 that his driver had no driving license. All those exhibits are there.
Did you give a reply like that?
the police record showed that, my lord, based on that, my lord, such a finding was given. But, my lord,
What is the document that you are producing now?
Exhibit R3, my lord.
Huh?
Exhibit R3 letter alleged to be written by the owner of the vehicle stating that, my lord, the driver had no.
What is the document that you now produced?
But I have produced the DL extract itself, my lord, along with the application.
This was the gentleman who was charge sheeted?
Yes. The charge sheet, there is no charge sheet so far it offense under section 181 of the MA.
No, but was this the person charge sheeted?
Yes, Shihab.
Driving license?
If your lordship has got the trial court advocate, my lord, I can demonstrate. Without the, my lord, trial court record, I can't.
Remanded, my lord, so that we need evidence.
Remind madlangare?
Remand madisumi. He remained ex parte there. And now he has come up with certain.
The claimant not get money, no?
Para 3 of his affidavit may kindly be looked into, my lord, in support of the application for condonation of delay. He admits.
The owner of the vehicle was placed ex parte for the tribunal. An appeal is over now filed, contending that the tribunal has committed serious error in casting liability on the owner on the ground that the driver of the vehicle did not possess a driving license. Third counsel, Sri Ravi Shankar Shastri, contends that along with the application for production of additional evidence, the claimant has produced the extract of a driving license, which indicates that the driver of the vehicle valid and effective driving license. He has also produced rest of the said vehicle. In my view, since these two documents would go to the root of the matter, it would be appropriate to set aside the award and remind the matter to the tribunal. The direction of the tribunal to reconsider the entire matter after permitting the appellant to file his objections and produce the evidence that he wants to rely upon, including the two documents that produced along with this appeal. Consequently, the appeal is allowed and the matter is adjourned.
That amount deposited may be paid to the claimant. Why they should suffer?
The tribunal shall pass appropriate orders on this amount after the disposal of the claim petition. I think in a delay of 126 days in Canadian.
Date may be fixed for appearance, Lord. Date may be fixed for appearance.
An entered appearance here, they are directed to appear before the tribunal on 4th of April. 4th of April.
4th of April.
They cannot know. Again injury?
Tibra malad and burst fracture, deep wall vertebra. Facial bone. Missing number 1878 malad 2016.
Which percent disability ಹೇಳಿದ್ದಾರೆ?
Doctor stated malad 79%, 97 is the whole body disability.
How much is the tribunal taken?
24% is 35% is considered.
In disability ಏನಾಗಿದೆ? How old was he? Sorry, but disability and if you mentally may be all right. Correct?
Around 19, page number 19 and first line. PWC stated that PWC suffer equal structure with a complete.
Yeah, paragraph.
Page number 19.
Paragraph.
Page number 19. One line of the judgment. In page.
The paragraph 18 is the line. It is argued that the in my paper book it says it is argued that in the case sheet of Sparsha.
Yes.
Then I know your thoughts.
Since the challenge the liability, quantum of income awarded.
Ability and
If the state burden, right petition to compensation for the damages caused and loss of income.
yes,
And
it is.
in this case, you also carried out the first round of findings. The insured driver of the insured vehicle did not possess a valid license. Second ground is the tribunal ought not to have granted any loss of income since the KSRTC, as per law, has to maintain spare vehicles which have been used as per the evidence of the petition. There was no loss of income. And Charles Street is filed against the
Loss of the
spare vehicles are
spare vehicle use ಮಾಡ್ಬೇಕಾದ್ರೆ ಇನ್ನೊಂದು ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ಮಾಡ್ಕೋಬೇಕಲ್ಲ ಅವರು.
spare vehicle is income loss of income ಇಲ್ಲ ಅದೇ
ನನ್ನ ಹತ್ರ 100 ಬಸ್ ಇರಬೇಕು. 100 ಬಸ್ ಇರೋದಕ್ಕೆ ಒಂದು ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ತಗೋಬೇಕು. ಅಷ್ಟು 101 ವೆಹಿಕಲ್ ನಾನು ಕಾಸು ಕೊಟ್ಟಿರ್ಬೇಕು. 101 ವೆಹಿಕಲ್ ಆ ಕಾಸ್ಟ್ ತಗೊಂಡೆ ನಾನು ಫೇರ್ ಫಿಕ್ಸ್ ಮಾಡೋದು. ಸೊ ಒಂದು ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ಯೂಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಇನ್ನೊಂದು ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ನಾನು ತಗೋಬೇಕು ಇವಾಗ. ಐ ಕಾಂಟ್ ರನ್ ವಿದೌಟ್ ಎ ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ಅಟ್ ಎನಿ ಟೈಮ್. ಸೊ ಐ ಹ್ಯಾವ್ ಟು ಸೆಟ್ ಅಪಾರ್ಟ್ ಒನ್ ವೆಹಿಕಲ್ ಆಸ್ ಎ ಸ್ಪೇರ್ ವೆಹಿಕಲ್. ಅದರಿಂದ ಒಂದು ಗಾಡಿಯವನ್ನ ಅವ್ರಿಗೆ ಆದಾಯ ಆಗಲ್ಲ. That is a requirement of their law also. How can you take the benefit of it? If this vehicle was being running regularly without the accident, it would have earned revenue.
They have used spare vehicle for not actually income at all.
ಏನಾದ್ರೂ 2 ಕಾರ್ ಇತ್ತು ಅಂದ್ಬಿಟ್ಟು 1 ಕಾರ್ ಆಕ್ಸಿಡೆಂಟ್ ಆದ್ರೆ
regarding that license, we have not produced any documents before. But
ಬಸ್ ಡ್ರೈವರ್ ಲೈಸೆನ್ಸ್ ಇರಲಿಲ್ಲ. ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡ್ಕೊಳ್ಳಿ.
Your Lordship, I kindly note that section 92 of MD Act.
You are not the enforcing agency for the RTO. Why are you doing the job of an RTO inspector? Let us assume they violate that section 92. How can you take advantage of that?
No, I am not taking advantage of it. The law provides that if there is
this vehicle did not run for X amount of days. This vehicle therefore did not earn revenue to the owner.
that revenue will have to make up. If there is some requirement of maintaining a spare vehicle, that does not mean that you will stand to benefit. You are the they are bound to use spare vehicle because they're a public utility. See, that cost is included into this revenue.
Discuss ಮಾಡಿ section 82 discuss ಮಾಡಿ 79A Karnataka motor vehicle rules ಮಾಡಿದ್ದಾರೆ. The law mandates that they have to maintain spare vehicles. And evidence also ಹೇಳಿದ್ದಾರೆ utilized services of spare vehicle and by not costing.
Moment they use a spare vehicle for this particular route, they also have to have one more spare vehicle. They cannot run this fleet without there being a spare vehicle. This is the requirement of a law that they have a spare vehicle. I'm accepting their contention. If there are 100 vehicles, one vehicle will have to be the spare vehicle. In the event of a breakdown, that spare vehicle will be used. Automatically, there's one more spare vehicle created. There is always a loss of one vehicle. ಇನ್ನೊಂದು ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ಹೌದು ಇವತ್ತು ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ನಾನು ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತಿದ್ದೀನಿ. ಆ ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ಯೂಸ್ ಮಾಡ್ಕೊಂಡ ತಕ್ಷಣ ಇನ್ನೊಂದು ವೆಹಿಕಲ್ ಆಟೋಮೆಟಿಕ್ ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ಆಗುತ್ತೆ. There's no such thing as for 10 days there won't be any spare vehicle at all. Suppose there's one more emergency there. So what do? They have used the spare vehicle. I'm not denying that fact, but it is not the question of their loss of income. It's their ability to earn revenue from this vehicle. That is the subject matter of the claim. So if I'm a rich person and I meet with an accident, I don't have any income. So according to you, there's no loss of income and I don't have to pay any compensation. How are you concerned with route catch, stage catch permit? We will assume they violate their stage catch permit. It makes no difference. This vehicle did not earn revenue to them. They have made an investment. I am accepting it. I am accepting the fact that they use a spare vehicle. But how will it absolve you of damages? See, they'll have bookings. The moment an accident occurs, they can't raise their hands and say, no, I have no vehicle, I will not fly today. They have a responsibility. They will have to run the vehicle. The fact remains is they lose revenue from this particular vehicle. Hangare prakara damage illa, therefore ಏನು ಕೊಡೋದೇ ಬೇಡ ಅಂತ. That is for the purpose of granting a stage carriage permit. That is not for enabling the insurance company to escape its liability to pay damages. How are you equating the two? So that is a damage, isn't it? That also you're bound to pay. This is also one concept of damage. Loss of revenue because they are not able to use that vehicle.
Rule 69A. Maintenance of reserve vehicles. Karnataka motor vehicles. 69A. The condition regarding maintenance of reserve vehicles specified in clause and 17 of subsection 2 of section 17 in the Act shall be incorporated in every permit granted to a person, and the maximum number of reserved vehicles to be maintained will be with valid permit to such use shall be as specified in the table below.
Now, number of permit 51 and above, not less than 10% of the fleet strength is the requirement. Correct. Let us assume they have 100. So they have to keep 10% as the reserve vehicle. One vehicle meets with an accident. So one comes from the fleet strength of 10. Shouldn't that again 10% be maintained? Should they not again spare one vehicle there? Will they not suffer? One vehicle will have to go out of circulation. So there is a loss of revenue.
Loss of
Second round, please, 10 vehicles as a fleet owner I set apart because the rule requires that I should keep 10 vehicles. The other 90 vehicles that I'm running to meet with an accident, I will draw these 2 from the reserve fleet. It becomes 8. There's a stage carriage permit violation. I have to again set apart 2 and keep it as 10 only. Will I not lose revenue for those 2? But the use of a spare vehicle is only for this purpose, to ensure that the public interest is safeguarded. There's always stage carriage is granted for a public purpose. Vehicle should always be run. It is being run. I'm straight away conceding your argument. So spare vehicle is used. This reserve strength will automatically go down.
Because they are using the other.
Correct. Reserve ನನ್ನ ಪ್ರಕಾರ 10 ಇರಬೇಕು. 10 ಒಂದು ಸ್ಪೇರ್ ವೆಹಿಕಲ್ ತಗೊಳ್ತೀನಿ, 9 ಆಗೋಗುತ್ತೆ. ಇನ್ನೊಂದು ವೆಹಿಕಲ್ ನಾನು ಕಾನೂನು ಪ್ರಕಾರ 10 ಇಟ್ಕೊಳ್ಳೇಬೇಕಾ? ಯಾವುದೋ whether exigencies or not, I always have to maintain 10. The moment I draw 1 from there, I will stop some other vehicle and I have to make good the 10. The 10 should always be maintained. So either way I will lose.
This point I have considered very important.
Did you consider this? Did you consider this argument? That that reserve spare vehicle.
Para 8 and 9 is down. In respect of the contention, it has been raised.
This point is not considered, that they'll have to set apart one other vehicle for reserving that fleet. That has not been considered here.
Next, page 10 of the presentation, I will refer to the.
Yes, para 11.
In such and such a case, I said that the corporation is not entitled for loss of revenue.
Yeah, judgment idea. Judgment idea 2 to 143.
Loss of income is not there. It is equivalent in such a
2 to 143 by 2 to 143 by 2000. 641 by 2000. 6 2014. Records in any case. I'm accepting the fact. Why are you arguing on that? The KSRTC admits that they use a spare vehicle. That is all. Tomorrow.
ಅಪೆಲೆಂಟ್ ಮೇಲೆ ಕ್ವಾಂಟಮ್ ಇಂಜುರಿ ಕೇಸ್
serial number
28.
GVR ಗೆ
ಅಪೆಲೆಂಟ್ ಮೇಲೆ
injury case
ಇಂಜುರಿ ಕೇಸ್ ಮೇಲೆ ಓಪನ್ ಟೈಪ್ ಸೆಕೆಂಡ್ ಕಮ್ಯುನಿಟೆಡ್ ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಡಿಸ್ಟಲ್ 1/3 ರೈಟ್ ಫೀಮರ್ ಮೇಲೆ ಇದರಲ್ಲಿ ಡಿಸಬಿಲಿಟಿ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. ಒಂದು ಪಾಯಿಂಟ್
ಡಾಕ್ಟರ್ ಇದರ
ಡಾಕ್ಟರ್ ಮಾಡಿಲ್ಲ ಇದರಲ್ಲಿ, ಆದ್ರೆ ಅದರಿಂದ ಓಪನ್ ಫ್ರಾಕ್ಚರ್ ಇದೆ.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
1,09,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. ಡಿಸಬಿಲಿಟಿ ಒಂದು ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ.
ಡಿಸಬಿಲಿಟಿ ಏನಿದೆ ಎವಿಡೆನ್ಸ್ ತೋರಿಸಿ ಕೇಸ್
ಎಕ್ಸಿಬಿಟ್ P9 my lord. ಡಿಸ್ಟಲ್ ಫೀಮರ್ ಲಾಕಿಂಗ್ ಪ್ಲೇಟ್ ಪರ್ಚೇಸ್ ಮಾಡಿರೋದಕ್ಕೆ ಬಿಲ್ ಇದೆ. ಆಮೇಲೆ ಫೋಟೋಸ್ ಇದೆ ಎಕ್ಸಿಬಿಟ್ P11.
ಅದರಿಂದ ಹೆಂಗ್ ಹೇಳಿ ನಾ ಡಿಸಬಿಲಿಟಿ? How old was he?
25 years my lord. ಎಕ್ಸಿಬಿಟ್ P11 ಫೋಟೋಸ್ ಇದೆ ನೋಡ್ಬೇಕು.
ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಇದನ್ನ ಇದೆಯಾ?
ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಫೈಲ್ ಮಾಡಿಲ್ಲ, ಒರಿಜಿನಲ್ ಇಲ್ಲ ಫೈಲ್ ಇಲ್ಲ.
ಮತ್ತೆ what is that I can do? On what basis can I assess disability? ನೀವೇ ಹೇಳಿದ್ರ ಫ್ರಾಕ್ಚರ್ಗೆ ಇಷ್ಟು ಪರ್ಸೆಂಟ್ ಡಿಸಬಿಲಿಟಿ ಅಂತ ಒಂದು ಸೈಟೇಷನ್ ಕೊಟ್ಟು ನಾನು ಅದನ್ನೇ ಕನ್ವಿನ್ಸ್ ಫಾಲೋ ಮಾಡ್ತೀನಿ.
MF 100/16 ಅಲ್ಲಿ ಬೋತ್ ಬೋನ್ಸ್ ಫ್ರಾಕ್ಚರ್ ಗೆ 10% ಡಿಸಬಿಲಿಟಿ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೂ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
MF
100/2016
ಇದೇ ತರ ಫ್ರಾಕ್ಚರ್ ಅದು
ಅಲ್ಲ, ಅದು ಇದು ಸಮಯ ಟಿಬಿಯಾ ಮತ್ತೆ ಪಿಬುಲಾ, ಇದು ಫೀಮರ್ ಇದು.
ಏನ್ ಮೇಡಮ್? ಬಟ್ ಈ ಅಲ್ಲ ಫೀಮರ್ ಫ್ರಾಕ್ಚರ್ ಗೆ ಎಷ್ಟು ತಗೋಬಹುದು?
ಓಪನ್ ಫ್ರಾಕ್ಚರ್ ಇದು.
ಇಲ್ಲಿ ಸಬ್ಜೆಕ್ಟ್ ಹಿಮ್ಸೆಲ್ಫ್ ಟು ಮೆಡಿಕಲ್ ಬೋರ್ಡ್ ಡಿಸಬಿಲಿಟಿ ಅಸೆಸ್ ಮಾಡಕ್ಕೆ ಕಳಿಸ್ತಾರೆ ಈಗ.
ಹಾ ಸರಿ ಸರ್.
ಏನ್ ಮಾಡೋದು ನೀವು ಒಪ್ಕೊಂಡ್ರೆ 5% ಅಂತ 5% ಮಾಡ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ.
I am for the appellant, my lord. There is delay of 10 days in filing the appeal, my lord. It may be.
Matter ಏನು ವೆಂಕಟೇಶ್?
Huh?
Matter ಏನು?
Matter, my lord, no, involvement of the vehicle is not there. I have challenged the question of involvement of the vehicle. The records are necessary, my lord.
The records are necessary. And don't office to secure the records. Records. ಮಹೇಶ್ ಅವರೇ,
ಮಹೇಶ್, yes, serial number 30 my lord.
Yes,
but this is a case of my lord death of a pillion rider. Nexus has not been proved, my lord. That's my grounds, my lord. Kindly be looked into. Ground number 5B, C, D and F and G are very important. The date of accident, my lord, is 8/4/2016.
yes.
But the driver of the insured car, one Mr. Gautam, was prosecuted, my lord, for the alleged accident. He pleaded guilty before the JMC Buddhi on 13/7/2018. In page 7, my lord, ground F, and paid a fine, my lord, on that. Then, my lord, the death was said to be on 28/9/2016.
28/9.
And charge sheet was filed against the car driver, my lord, again in CC number 96/2017. And he was acquitted under section 304A IPC. He was acquitted on the ground, my lord, evidence of PW 8 and 10 doctors who conducted the postmortem report, my lord, did not prove the nexus between the death and the injuries caused on 8/4/2016, while the death was on 28/9/2016. And before the tribunal also, my lord, no medical records were produced to prove the cause of death.
Medical evidence, sir?
No medical evidence was.
Medical evidence?
Exhibits, my lord, ink page 22, exhibit may kindly be looked into. 2 mahazars, my lord.
PM report ಏನಂತ ಹೇಳುತ್ತೆ?
PM report, my lord, the cause of death is not this thing. PM report is not produced.
ಅದು exhibit P4 ಅಂತ ಇದೆ.
ಯಾವುದು?
Annexure ಅಲ್ಲಿ ಇದೆ exhibit P4 ಅಂತ.
P4 ಅಲ್ಲಿ cause of death is not mentioned, my lord.
ಹಿಂಗಿದೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಹೇಳಿ ನೋಡಿ, a male body was brought to for postmortem from Gubbi police station with history of RTA on 8/4/16. Since then he was in coma.
Blood death.
This is the postmortem report.
That is the postmortem report, my lord.
He was in coma from 8/4/2016. For 5 months he was in coma. Can the death be related to some other cause?
The cause of death, my lord, cannot be, my lord. Coma can be, my lord, for so many other reasons.
ಅಲ್ಲ ಇಲ್ಲಿ ಬರ್ದಿರೋದು ಆಕ್ಸಿಡೆಂಟ್ ಆದ ಕೋಮಾ ಅಂತ. With history of road accident on 8/4/16. Since then he was in coma.
Yes, my lord. My lord, the driver of the car, my lord, was acquitted by the tribunal.
So nexus is there, isn't it?
Illa, that's what, my lord, the criminal court, my lord, say. Doctors, my lord, who were examined as PW 8 and 9, my lord. The finding of the.
This is the opinion. I am of the opinion that cause of death is due to septicemia, secondary to head injury.
That secondary was different.
To head injury.
Primary, my lord, it is not primary. You have to kindly see whether he had any other ailment, my lord, that is the thing.
Ayeshwar, he was in coma for 5 months.
Maybe, my lord, I am not the thing, my lord, whether due to the injury. And moreover, the fact that he was, my lord, not wearing the helmet is proved.
ಅಲ್ಲ that ಬೇರೆ argument. ಇದು accident ಇಂದಾನೆ ಅವನು ಕೋಮಾಗೆ ಹೋಗಿದ್ದ, ಅದನ್ನ ಒಪ್ಕೊಡ್ತೀರಾ ನೀವು?
Voluntary non-fit injury, my lord, comes into picture because he was not wearing the helmet. Section 123 of the Motor Vehicles Act.
All right.
Then, my lord, count number 7 may kindly be looked into, my lord. For a 2016 accident, my lord, 10,000 notional income has been taken. 1/4, my lord, instead of, my lord, 1/2. Because the claimants 3 and 4 were married. They were not the dependent. And regarding the age, my lord, the ration certificate, my lord, the ration card itself shows, my lord, he was aged 56. Marked as P17. But the multiplier taken is 13, which is not correct. Exhibit P17, ration card produced by them. Exhibit P17, 17.
ಮೆಡಿಕಲ್ ಬಿಲ್ ಎಷ್ಟಾಗಿದೆ? 5,95,000. P17.
Yes. Ration card.
50 ಅಂತ ಇದೆ, 50 ವರ್ಷ ಅಂತ ಇದೆ ಶಿವಣ್ಣ. ಯಜಮಾನ 50 ವರ್ಷ ಅಂತ ಇದೆ.
Hello, you 50 ವರ್ಷ, you are more than 56.
ಅಲ್ಲ, ಬಟ್ ರೇಷನ್ ಕಾರ್ಡ್ 50 ಅಂತ ಹೇಳುತ್ತೆ.
Date of issue may kindly be looked into, my lord. On the date on which it was issued, the age is disclosed.
5/9/2009.
Yes.
Not very sure that is the date.
Date of accident, my lord, is
14.
14. 16, my lord, 16.
16 or 14? 16.
Yes.
55 years ಸರಿ ಹೋಗುತ್ತಲ್ಲ. 55 years.
55 years ಗೆ multiplier, my lord, would be 13.
ಅದು ಚೇಂಜ್ ಮಾಡೋಣ. ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
Income, my lord, 10,000 ತಗೊಂಡಿದ್ದಾರೆ for an accident of 2016. Even by notional income, my lord, it will be 9,500.
What was he?
My lord, he was said to be, my lord, a coconut
and
businessman.
ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ ಇನ್ಕಮ್ಗೆ?
ಎವಿಡೆನ್ಸ್ ಏನಿಲ್ಲ. The court itself says, my lord, notional income.
He's got 3 children.
But 3 and 4 are married, admittedly. There is no dependency. They were residing, my lord, with their matrimonial house.
He has spent 6 lakhs on his medical expenses. Alva?
But that is subject to, my lord, this thing.
Apart from medical expenses, they also have to be paid that conveyance, nutrition and Alva.
But I am challenging, my lord, the cause of death in the first instance.
I will consider that.
Yes. Then, my lord, the notional income should have been 9,500 instead of, my lord, 10,000. And the age should have been 56 years. And the choice of multiplier should be based on age 56. Then, my lord, claimant 3 and 4 are married. They are not dependents. Therefore, my lord, it should have been 1/2 instead of 1/4.
The district hospital records his date of his age as 55 years.
But ration card and all that, my lord, both are this thing.
55 years ಎಲ್ಲ ಕಡೆ.
ಅಲ್ಲ, ರೇಷನ್ ಕಾರ್ಡ್ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ 56 ಆಗುತ್ತೆ. 9 multiplier.
ರೇಷನ್ ಕಾರ್ಡ್ಗೆ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಲ್ವಲ್ಲ?
ಅಲ್ಲಲ್ಲ, the date on which it is issued, age is mentioned in the ration card. Accident is of 2016.
No, even in the MS Ramaya hospital, date of birth is also mentioned as 20th of February 61. So it becomes 55 years.
That is on the saying of the my lord, but exhibit P17 ration card produced by them.
ಎರಡನೇ ಪಾಯಿಂಟ್ ನಿಮ್ದು.
ಆಮೇಲೆ cause of death, my lord, is not proved. And you are not wearing helmet.
Very well.
If you were to helmet, my lord, wearing helmet, you would have saved his life.
Yes.
And section 123 of the Motor Vehicles Act. Then, my lord, the negligence on the part of the deceased pillion rider in not wearing the helmet. Thereby, my lord, it has to be discounted.
Where did the accident occur?
My lord, this is the Puttana Gate, my lord, near petrol bunk.
So is there a requirement for people at Gubbi also to wear a motorcycle helmet? I thought it was only to municipal corporations.
No, my lord, even on the highway. Highway, it is more, my lord, they are dangerous on the highway.
Right. Anything else?
ಅಲ್ಲಿ ಏನು ಮುನ್ಸಿಪಲ್ ಲಿಮಿಟ್ಸ್ ಅಲ್ಲಿ ಹಾಕೋಬೇಕು ಆಮೇಲೆ ಹಾಕೋಬಾರ್ದು ಅಂತೇನಿಲ್ಲ. ಮೋರ್ ಮೆಲಾಟ್ it will be for the safety of the melot. The pillion rider section 123 says that he has to wear.
But your insurance policy does not say that if you don't wear an helmet, I will not cover you.
But my respectful submission, my lord, insurance company does not say, but what I am considering, my lord, the negligence on the part of the my lord deceased in not wearing.
Right, I'll consider.
Let all the motor vehicle provisions cannot be incorporated in the policy.
Yes.
My lord, even otherwise you must kindly pursue, my lord. For example, my lord, if you were to wear the helmet, you would have saved his, my lord, head and life also.
Yes.
Because of the negligence, section 123 of the Motor Vehicles Act, my lord, is mandatory that he has to wear helmet. So even, my lord, for SST, for his own negligence, insurance company cannot be made liable to pay you to the entire extent.
What is your appeal for?
Cross objection.
ಏನ್ ಕಮ್ಮಿ ಆಗಿದೆ ಅದು ನಿಮ್ಮ ಪ್ರಕಾರ? ಅಷ್ಟೇನಾ? ಒಂದೇ ಅಷ್ಟೇ ಅಲ್ವಾ? On 8/4/2016, when Shivanna, the deceased, was proceeding as a pillion rider in a motorcycle, a Scorpio car hit the motorcycle from behind.
Not one more factor, my lord, the rider was not, injured. You must kindly see, my lord. Therefore, the negligence of the, my lord, pillion rider is evident.
Pillion rider ಹಿಂದ್ಗಡೆ ನೋಡ್ರೆ ಅವನದೇ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ, ಫಸ್ಟ್ ಪರ್ಸನ್ ವುಡ್ ಬಿ ದಿ ರೈಡರ್ ಆಫ್ ದಿ ಮೋಟರ್ಸೈಕಲ್.
ಅಲ್ಲ, ಹಿಂದ್ಗಡೆಯಿಂದ ಬಂದು ನೋಡಿದ್ರೆ ಫಸ್ಟ್ ರೈಡರ್ ರೇಟ್ ಬೀಳುತ್ತಾ, ಪಿಲಿಯನ್ ರೇಟ್ ಬೀಳುತ್ತಾ?
ಅಲ್ಲ, ಹಿಂದ್ಗಡೆಯಿಂದ ಬಂದು ಹೊಡೆದ್ರು ಬೋತ್ ವಿಲ್ ಬಿ my lord, the.
ಅಲ್ಲ, but what is the negligence on the pillion rider sitting behind? That is negligence, sitting as a pillion rider.
Pillion rider, my lord, without wearing the helmet, even for example, my lord, hit by from front or from the back, my lord. Okay. If you were to wear the helmet, my lord, he would have saved his life. Exhibit P5 IME report में kindly be looked into. Two hazards.
This resulted in Shivanna suffering from previous injuries.
The evidence on record indicates that he was initially treated at Columbia Asia Hospital from 8/4/2016 to 20th of April 2016, and thereafter he was admitted to MS Ramaya Hospital, where he underwent treatment from 20th of April 2016 to 29th of May 2016.
Shivanna ultimately succumbed to injuries on 29/9/2016, and this resulted in the filing of the claim petition. The tribunal, on consideration of the evidence produced before it, came to the conclusion that the death of Shivanna was due to the rash and negligent driving of the owner of the Scorpio car, and his LRs were entitled to a total compensation of ₹19,14,978. The insurer of the Scorpio car is an appeal. The claimants are also in appeal, or have also filed a cross objection seeking for an answer. C.O. Mahesh, Learned Counsel appearing for the insurer, strenuously contends that the death of Shivanna had no nexus to the accident, and therefore compensation could not have been awarded by the tribunal. He alternatively submits that since Shivanna was not wearing an helmet, his death was due to his own negligence, and as a consequence, the insurer would not be liable. Innೊಂದೇನು contention ನೀವು ಹೇಳಿದ್ದು ಮೂರನೇದು?
No, the two Mahazars and the driver was acquitted in the criminal court on the evidence of Dr.
Learned Counsel also
8
submits
and 9.
that the criminal
Nexus has
case,
not been proved.
the criminal prosecution that had been launched against the rider of the Scorpio car had ended in an acquittal, and the evidence adduced there indicated that the cause of death had not been mentioned, and therefore the death of Shivanna could not be attributed to the accident. Learned Counsel for the claimant on the other hand contends that the determination of income at ₹10,000 is on the lower side. He also submits that the tribunal has committed a serious error in not awarding future prospects, and the award of loss of consortium only to one person was incorrect.
One submission, my lord, you also mentioned the rider of the motorcycle. It is driver of the Scorpio.
ಅದನ್ನೇ ಹೇಳಿದ್ ನಾನು.
I heard it as a rider.
No. ಅದನ್ನೇ ಹೇಳಿದೆ ನಾನು.
Maybe check, my lord. Maybe.
The criminal prosecution had launched against the driver of the Scorpio car.
Yes.
The argument of the Learned Counsel that the death of Shivanna had no nexus to the accident cannot be considered at all. The postmortem report, which was produced as Exhibit P4, contains the following statement. The PM report also states that the cause of death was due to septicemia secondary to head injury. The claimants have produced the entire case sheet of MS Ramaya Hospital. And also, Columbia Shadu hakidara. Also Columbia Shadu Hospital, which indicates that he was hospitalized from 20th of April 2016. Research summary, yeah.
That exhibit R5 may kindly be looked into, my lord. R2, R3 and R5. R6 also inpatient record produced by the insurer in support of their contentions. Exhibit R2, R3, R5 and R6.
This was someone from the Ramay Hospital, isn't it?
Yes, madam. Exhibit R2 outpatient record. R3 is the inpatient record. R5 is the MLC extract.
The entire
R6 is another inpatient record.
records from MS Ramay Hospital were summoned, and the discharge summary of MS Ramay Hospital indicates that Shivanna was confirmed with the diagnosis of road traffic accident with diffuse axonal injury. The course in the hospital reads as follows: CH-19. As could be seen from the postmortem report and the discharge summary, Shivanna was hospitalized till the end of May 2016, and he was on ventilator and thereafter treated with supportive care. The postmortem report, in fact, indicates that he was in a coma ever since the date of the accident, and the ultimate cause stated there is that he died due to septicemia as a result of an head injury. It cannot be in dispute that if a person is in coma for almost 4 months, the probability of him suffering septicemia would be a natural course in his deteriorating health. And in this view of the matter, the argument that there was no nexus with the road accident.
Exhibit R5 can.
That's what I'm holding.
The MLC extract.
I'm reading the discharge summary of MS Ramay Hospital, which you have summoned.
Now produce the exhibit R5 now.
That's what I have recorded. Cannot be accepted. The second argument advanced was that the criminal case launched against the driver of the Scorpio car ended in an acquittal, and therefore the insurer cannot be made liable, cannot also be accepted. It is settled law that neither an acquittal nor a conviction in a criminal case is determinative of the negligence in a motor vehicle proceedings. In a claim under the Motor Vehicles Act, the case will have to be decided on the preponderance of probabilities and not on the basis of proof beyond reasonable doubt. In this case, the fact that the driver of the Scorpio car was prosecuted is itself indicative of the negligence. The evidence on record clearly indicates that the Scorpio car hit the two-wheeler in which Shivanna was traveling, and the point of impact was
on the rear of the motorcycle. In this view of the matter, the argument that there was no negligence on the part of the driver of the Scorpio car will also have to be rejected. The third argument that since Shivanda did not wear an helmet, he had also contributed to the negligence, cannot also be accepted. A pillion rider, assuming he has violated the motor vehicle rules by not wearing an helmet, cannot be punished. His LRs cannot be punished for the death which occurred as a result of an accident. The requirement of wearing an helmet, even if prescribed by a statutory rule, would not entitle the insurer to claim exoneration of liability for a breach of that rule. If a traffic rule, if a motor vehicle rule is violated, the appropriate authorities would take appropriate action against the defaulter. The insurer cannot use that alleged breach to contend that there was negligence and therefore its liability should be exonerated. Admittedly, there is no condition in the policy of insurance which states that the liability of the insurance company will stand exonerated if the rider of the motorcycle and the pillion rider of the motorcycle not wear protective headgear. In the absence of any such specific stipulation under the insurance policy, the insurer cannot even put forth a plea that the breach of a motor vehicle rule would exonerate it of liability.
But I'm not asking for exoneration, but I'm only asking for negligence, my lord, that has to be reduced.
Further argument that negligence should be attributed as a result of the breach of the motor vehicle rule cannot also be accepted. A mere breach of a motor vehicle rule would not tantamount to negligence. Negligence is an aspect which should be the direct cause of the accident, which would result in a reduction of the compensation. A mere flouting of a motor vehicle rule cannot by itself lead to an inference that there is negligence on the offender. Negligence is a fact which has to be pleaded and proved. In cases where it is pleaded that non-wearing of a protective headgear resulted in the accident, only then can the insurer claim that there was some attribution of negligence on the part of the offender. If the non-wearing of the protective headgear had no relationship with the accident at all, the insurance company cannot even put forth the plea of negligence. This argument is also therefore rejected. As a consequence, there is no meritocratic appeal of the insurer, and the same is
Quantum
the Learned Counsel for the insurer also contends that the sum of rupees 10,000 determined as notional income was incorrect since there was no evidence to support the claim. In respect of an accident of year 2016, the KSNSA itself has assessed the monthly income at rupees 9,500. In this case, the evidence on record indicates that the claimant, the deceased, had left behind him a wife and 3 children, some of whom were also married. And this also indicates that his income could easily be taken as rupees 10,000. And the tribunal has correctly assessed the income at rupees 10,000. The argument, therefore, that the assessment of monthly income is excessive is also rejected. As far as
claimant number 2 was a major, 3 and 4 are married, they are not the dependent.
As far as the
claim for enhancement is concerned, the assessment of rupees 10,000 per month is, as already said, about just and proper. So, however, the criminal is not awarded added future prospects. Accordingly, to the set sum of rupees 10,000, 25% is added as future prospects, and this would result in a monthly income to rupees so on so. The out of the said sum, the 1/3 deducted towards the personal expenses of the deceased. The resulting monthly is so on. The medical record of MS Ramaya Hospital has recorded the date of birth of the deceased as 20th of February 1961. This would indicate that the deceased Shivanna was 55 years, and consequently, the multiplier of 11 will have to be adopted. As a result, the claimant will be entitled to some rupees 11 towards loss of future dependents. The claimants being the mother and daughters. Each of them 44,000. The further sum of rupees 33,000. The convention rates. As already noticed above, Shivanna was in coma from the date of the accident till he passed away in September 2016. The evidence on record indicates that he was hospitalized till 29th of May 2016 at MS Ramaya Hospital. In my view, having regard to the length of his hospitalization and the fact that he was in coma, it would be necessary to award a sum of rupees 1,50,000 towards conveyance, food and nourishment, and attendant charges. The sum of rupees 6,74,978 granted towards medical expenses being based on bills are affirmed. Consequently, the claim will be entitled to the following sums. They condemn. 2,300 days.
In my case, for an amount in deposit to be transferred to MACT.
Pardon.
I appear for the respondent in this case, my lord.
ಏನ್ ಕೇಶ ಪ್ರಶಾಂತ್ ಅವರೇ ನೀವು ಬರೋದೇ ಇಲ್ಲ ನೀವು
ಹೆಲ್ತ್ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ
ಯಾರಿಗಾರು ಹೇಳಿಲ್ಲ ನಾನು ಕಾದು
ಇಲ್ಲ
ask at least somebody to take care of your cases.
ಇಲ್ಲ ಇನ್ಮೇಲೆ ರೆಗ್ಯುಲರ್ ಆಗಿರ್ತೀನಿ the delay of 362 days, my lord, in filing the appeal.
ಏನ್ ಕಮ್ಮಿ ಆಗಿದೆಯಾ ಏನಾರು ಏನ್ ಕಮ್ಮಿ ಆಗಿದೆ ಕಾಂಪನ್ಸೇಷನ್ ತಗೊಂಡಿದ್ದಾರೆ 10 ವರ್ಷ ಹತ್ರ ಕಾದ್ರೆ ನೀವು ಏನ್ ಕಮ್ಮಿ ಆಗಿದೆ ಪ್ರಶಾಂತರ
Judgment illa natra. I have only appeal memo, my lord. As per the appeal, my lord, contentions taken, the income considered at 3,000 rupees.
Give me a copy.
Please, my lord. My lord.
Judgment copy ಕೊಡಿ ಅವ್ರಿಗೆ ಒಂದ್ಸಲ ನೋಡ್ಲಿ ಅವ್ರು ಎಷ್ಟು ಕಮ್ಮಿ ಅಂತ ಹೇಳಿ ನೋಡೋಣ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ಲಿ ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮುಗಿಸ್ತೀನಿ ನಾನು ನೀವು ನೋಡ್ಬಿಟ್ಟು
ಇಲ್ಲ ಮಾಡ್ತೀನಿ
number 1 madam.
ಯಾರಿಗೆ ಏನಂದ್ರೆ ಅಲ್ಲಿ ಓನರಾ
ಪರ್ಮಿಟ್ ವೈಲೇಷನ್ ಆಗಿದೆ ಅಂತ ಲಯಬಿಲಿಟಿ ಫಿಕ್ಸ್ಡ್ ಆನ್ ದಿ ಓನರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್.
ಮಹೇಶ್ ಅವರೇ
Yes.
Seal number 32.
30, my lord, requires LCR, my lord.
The permit condition violation ಅಷ್ಟೇ ಅಂತ
Illa. The owner, my lord, has appeared before the scene. Now it contention in support of the application for condonation of delay of 1,231 days is that not sought before the tribunal. Therefore, my lord, to prove that the LCR is required whether the party was served or not. Whether this contention that
What does the tribunal say?
Pardon?
What does the tribunal say?
Tribunal
Tribunal
says,
ಸರ್ವಾಗಿತ್ತು ಅಂತಾರ?
and moreover, my lord, 50% has not been deposited. That makes, my lord, appeal not maintainable in compliance of the court order. Appellant was deposit 50%.
ಮಾಡಿದ್ದೀರಾ?
Not deposited.
ಮತ್ತೆ?
Appeal itself would not be maintainable.
ಬಂದಿಲ್ಲ ಜಯಂತ ಏನಂತ? ಬಂದಿದ್ರೆ ಯಾವತ್ತಾದ್ರು? DNP ಮಾಡ್ರೆ ಅಷ್ಟೇನಾ? ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ ಹೇಳಕ್ಕೆ. ಅವ್ರು ಒಪ್ತಾ ಇಲ್ಲ ಅವರು.
Let him comply with the order, my lord, deposit of 50%.
ಅವ್ರು ಬಂದಿಲ್ಲ ಅವರು. ಅವ್ರು ಬಂದೇ ಇಲ್ಲ ಅವರು. ಸುಮಾರು ಸಲ ಅಡ್ಜಾರ ಆಯ್ತಲ್ರಿ ಅದೇ ತರ. Last chance, released one.
Is it passed over or urgent, my lord?
Urgent.
Please.
ಪ್ರಶಾಂತ್ ಅವರೇ.
The negligence issue.
ಏನ್ ನೆಗ್ಲಿಜೆನ್ಸ್?
Blood, 2 billion riders were traveling in the motorcycle at the time of accident.
Yes.
And further, my lord, insurance company officer, my lord, is examined as RW1 before the MACT and produced.
One case of death,
Oh, ಎರಡು death. Minors.
ಚಾರ್ಜ್ ಶೀಟ್ ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ರು?
Charge sheet, my lord, is filed against the driver of the, my lord, the insured vehicle. Where, my lord, we have produced the copy of the judgment of the magistrate court, my lord, which is in CC number 580 of 2050. Wherein, my lord, the London magistrate, my lord, has given the definite finding, saying that, my lord, there was no negligence on the part of the driver of the insured vehicle. It was negligence on the part of the, my lord, the rider of the motorcycle in question. So just I wanted to, my lord, take your lordship's kind attention to that aspect, my lord. So based on that, my lord, we have required this appeal. It was produced as exhibit R3, my lord.
Yes. So now that becomes relevant according to you, the judgment of the magistrate.
After all, because e case, particular case, otherwise, my lord, I would have not said this. This particular case.
On a principle, then the acquittal also would result in
finding one note, but bear argument. This is the only thing, my lord, just I wanted to take your lordship's kind attention on this. That exhibit R3, my lord, page number 4 of the, my lord, the judgment, paragraph number 12, my lord.
R3 idea. ಏನ್ ಹೇಳುತ್ತೆ?
Specific definite finding ಕೊಡ್ತಾರೆ. There was no negligence, and it was the rider of the motorcycle who came and dashed to the back rear wheel of the vehicle in question. That was not, my lord, properly considered by the MSCT. That because of that reason, my lord, I am requesting your lordship to look into that. ಹಿಂದ್ಗಡೆ ನನ್ನ ರೈಟ್ ಸೈಡ್ ರೇರ್ ವೀಲ್ ರೈಟ್ ಸೈಡ್ ವೀಲ್ಗೆ ಬಂದು ಹಿಂದ್ಗಡೆಯಿಂದ ಹೊಡೆದಿಲ್ಲ ಮೋಟರ್ಸೈಕಲ್.
ಎಲ್ಲಾಗಿದೆ ಆಕ್ಸಿಡೆಂಟ್ ಇದು?
Blood, it was in the Chikmagalur Kadur main road, blood.
Who was examined?
Like the insurance company officer is examined and we have produced this judgment, my lord.
Did you examine the driver?
No, my lord, driver is not examined in this case.
Then
ಒಂದ್ಸಲ ಅದೊಂದು ಫೈಂಡಿಂಗ್ ನೋಡ್ಬಿಡಿ ಸರ್, ನಿಜವಾಗ್ಲೂ ತುಂಬಾ ಚೆನ್ನಾಗಿ ಬರ್ದಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ, ಸೀರಿಯಸ್ಲಿ. ಅಲ್ಲ, ಈಗ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್ ಹ್ಯಾಸ್ ಟು ಪ್ರೂವ್ ಇದು ಒಂದು ದಟ್ಸ್ ಎ ಡಿಫರೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್, ಬಟ್ ಈ ಕೇಸಲ್ಲಿ ರಿಗಾರ್ಡ್ ಟು ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಸ್ಪೆಕ್ಟ್ ಮೇಲೆ ಫೈಂಡಿಂಗ್ ಇಸ್ ಗಿವನ್.
the other R3 is the deposition.
ಕಾಪಿ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, CC number 580 of 2015 ಇದೆ.
ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ
ಅದರಲ್ಲಿ? ಆ ಡಿಪೋಸಿಷನ್ ಜೊತೆಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
ತುಂಬಾ ಚೆನ್ನಾಗಿ ಬರೆದಿದ್ದಾರೆ ಅಂತ
ನನಗೆ ಚೆನ್ನಾಗಿದೆ, ತಮಗೆ ಗೊತ್ತಿಲ್ಲ.
ಗೆದ್ದಾಗ ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ ಚೆನ್ನಾಗಿರುತ್ತಲ್ಲ, ಸೋತಾಗ ಮಾತ್ರ
ಎಲ್ಲ
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
% ಇಲ್ವೇ ಇಲ್ವಲ್ಲ ಸ್ವಾಮಿ.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
12 ಮೇಡಮ್, ಪೇಜ್ ನಂಬರ್ 4 ಆಫ್ ದಿ ಮಿಲಾಡ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಇದು ಹೆಂಗೆ ಪ್ಯಾರಾ 13 ಓದಿ ಒಂದ್ಸಲ. The admission of PW3 during his cross examination.
Discloses that right side rear wheel of the lorry has been passed over the deceased Nityashree and Sahana. If at all this lorry hit to the motorcycle while they are proceeding on the left side of the road, certainly there is no possibility of deceased were coming under the right side.
ಹಿಂದ್ಗಡೆ ಬಂದು ಹೊಡೆದಂಗ ಆಗಲ್ವಲ್ಲ? If the lorry has driven over them, no question of them hitting them from behind.
ಅಲ್ಲ, ಹಿಂದಿಂದ ಬಂದು ಅವರೇ ಹೊಡೆದಿರೋದು. ದಟ್ಸ್ ವಾಟ್ ಮಿಲಾಡ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ.
How will they go under the wheel, ಪ್ರಶಾಂತ್ ಅವರೇ?
ಅಲ್ಲ, ಇವ್ರು ಏನಾಗಿದೆ ಅಂದ್ರೆ 3 ಜನ
ಬಂದು ಹೊಡೆದ್ರೆ ಗಾಡಿಗೆ ಬೀಳುತ್ತೆ, ಕೆಳಗೆ ಬೀಳ್ತಾರೆ. How will they be run over?
He lost the control, Milord. He lost the control and dashed to the rear wheel. Sudden like pass agide ಅಷ್ಟೇ. You lost him kindly. I will read it.
How is it possible? You tell me. But 2 persons coming from behind hit a lorry. They go under the wheels of the lorry and come across.
ಮುಂದಕ್ಕೆ ಓದ್ತೀನಿ ಸ್ವಾಮಿ.
ಬಿಡಿ, ಅದು ಯಾಕೆ ಚೆನ್ನಾಗಿ ಬರ್ದಿಲ್ಲ ನೀವು. ಯುವರ್ ಅಸೆಸ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಕರೆಕ್ಟ್.
ಅಲ್ಲ, ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 8 ಅಲ್ಲಿ, ಪೇಜ್ ನಂಬರ್ 8 ಅಲ್ಲಿ 4 ಅಲ್ಲಿ, page number 8. Records sufficiently disclose that this accident is occurred only due to rash and negligent act of PW3 and the accident is not at all the result of rash and negligent act of the accused public lorry driver. The lorry being heavy vehicle, the police might have filed child charge.
ಅಲ್ವಾ?
ಅಷ್ಟೇ.
ಎಷ್ಟು ಕೋಟಿ ಇನ್ಕಮ್ ಏನು ಕಮ್ಮಿ ಆಗಿದೆ?
ಇಬ್ರು ಮೈನರ್ಸ್ 5 ಲಕ್ಷ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಎರಡರಲ್ಲೂ.
ಏನ್ ಕೆಲಸ ಮಾಡಿದ್ರೆ, ಏನ್ ಓದ್ತಿದ್ರು? ನೋಷನ್ ಇನ್ಕಮ್ ತಗೊಳ್ತೀನಿ.
ಅಲ್ಲ, ಮೈನರ್ಸ್
16 years SH ಓದ್ತಿದಾರಂತಲ್ಲ.
ಇಲ್ಲ, 16 years ಅಲ್ಲ, 15 years.
Exhibit P7 shows that 15 years 4 months and exhibit P24 also shows that 15 years 8 months. ಎರಡು this was
But
8999.
ಆಕ್ಸಿಡೆಂಟ್ ಯಾವಾಗ ಆಗಿದ್ದು? Sahana is born on 9/5/1999. What about the other girl? E24 Sahana. What about the other girl?
ಪ್ಯಾರಾ 16 ನಲ್ಲಿ ಇಬ್ರದು 15 years ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್. That is what the finding the MSCT. Para 16 of the judgment.
She is also born in 1999. Accident ಯಾವಾಗ ಆಯ್ತು ಅಂದ್ರೆ
2015 ಮೇಡಮ್. 4/1/2015.
15 ವರ್ಷ ಮೇಲೆ ಆಗ್ತಾರಲ್ಲ ಇಬ್ರು.
ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ನನಗೆ ಗೊತ್ತಾಗಲಿಲ್ಲ.
ಒಬ್ಬಳದು 8/9/1999 ನಿತ್ಯಶ್ರೀ. Sana is 9/5/1999.
15 years ಮೇಲೆ ಆಗುತ್ತೆ. 10th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ನೋಷನಲ್ ಇನ್ಕಮ್ ಬೇಡ ಸ್ವಾಮಿ, ಅದು ತುಂಬಾ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಬಿಕಾಸ್
ಆಗ್ಬೇಕಲ್ಲ, ಇಬ್ರು ಹೆಣ್ಮಕ್ಳು ತೀರೋದ್ರೆ.
ಇಬ್ರಿಗೂ ಕೊಡ್ತೇನೆ, ನಮಗೆ ಕೊಡಲ್ಲ ಅಂತ ಖಂಡಿತ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಲ್ಲ. ಬಟ್ ಇದು ಇನ್ಕಮ್ ಪ್ರೂಫ್ ಇಲ್ಲದೆ ಕೆಲಸ ಮಾಡ್ತಿದ್ದವರಿಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ಸ್ ಗೆ ದಟ್ ವಾಸ್
They appear to be doing well in studies also. They have gone to respectable schools. So they would have definitely some prospects in life.
I will leave it to Lashit.
The accident which occurred on 4/1/2015 between a motorbike and a Tata tipper lorry is not in dispute. The fact that Nityashri and her friend Sahna were killed at the spot is also not in dispute. The tribunal, on the assessment of the evidence adduced before it, has come to the conclusion that the driver of the tipper lorry was responsible for the accident and has proceeded to award a sum of rupees 5 lakhs to the parents of the deceased Nityashri and Sahna. Both the insurer as well as the legal representatives of the deceased are in appeal. The insurer principally contends that the driver of the tipper lorry who was prosecuted by the police was acquitted, and a finding was recorded by the magistrate that he was not negligent, and it was therefore necessary for the tribunal to exonerate the liability of the insurance company. Learned counsel for the claimants on the other hand contends that the fact that they were prosecuted by itself indicates that there was negligence on the part of the tipper lorry. He seeks to highlight the fact that the lorry in fact ran over both the girls, and this by itself was indicative of the negligence, especially when it is considered that the driver of the lorry would have a clearer vision having regard to his elevated seating position. The judgment upon which reliance is placed by the learned counsel for the insurer itself indicates that the two girls were run over by the tipper lorry. This indicates that the owner, the rider of the lorry, could easily see them and he has virtually run over them. And this by itself is indicative of his negligence. It is to be stated here that in respect of a proceeding under the Motor Vehicles Act, the principle of preponderance of probability will have to be adopted as against the principle of proof beyond all reasonable doubt, which is applied in criminal prosecutions. In this view of the matter, the acquittal in the criminal court would be of no consequence. And it will have to be held that the driver of the tipper lorry was responsible for the accident. The tribunal, in my view, has rightly come to the same conclusion. And the finding regarding negligence will therefore have to be affirmed. As a consequence, the appeal of the insurer is dismissed. As far as compensation is concerned, the tribunal has awarded a global compensation of rupees 5 lakhs for the death of both the girls. In my view, since the girls were studying in the 10th standard and both of them were aged above 15 years, the awarding of rupees 5 lakhs
as global compensation would be incorrect. In my view, it would be appropriate to adopt the notional income and applying the multiplier method, award compensation to the LRs of the deceased. Since the accident occurred in the year 2015 and the KSLS has determined the monthly income notionally at ₹9,000, the said income is adopted for determining compensation. As both the girls were aged 15.5 years, 40% will be added towards future prospects. This would result in the monthly income to be ₹7,000. The claimants would therefore be entitled to some ₹7,000 towards loss of future earnings. The claimants being the parents, each of them would be entitled to a sum of ₹44,000 towards loss of consumption and a further sum of ₹33,000 towards the conventional accident as a consequence of the table now.
50% deduction agಬೇಕು.
50%.
The amount in deposit may be transferred to Mirad MS.
Yeah.
Revenue retention property. Few properties
Don't want to go to the court, you want to be inside the court all that.
There are other properties. They are not agreeable.
Find an amicable solution. Why do you want to carry this further? For how many years do you want to litigate? Ask them to get the other 3 sisters. ಬೇರೆ ಅವ್ರ ಕಡೆಯವ್ರು ಯಾರೊಬ್ರು ಬರ್ಲಿ ಒಬ್ರು. ಇಲ್ಲ ನೀವೇನು ಎಷ್ಟು ವರ್ಷ ಈ ವ್ಯಾಜ್ಯ ಮಾಡ್ಕೊಂತ ಇದ್ರಮ್ಮ ನೀವು? ಬಿಲ್ಲಲ್ಲಿ ಏನಾಗಿದೆ? ನೀವು ಹಿಂಗೆ ಜಗಳ ಆಡ್ಕೊಂಡು ಕೂತಿದ್ರೆ ಇನ್ನೊಂದು 30 ವರ್ಷ ಹಿಂಗೆ ಜಗಳ ಆಡ್ತಾ ಇರ್ತೀರ. ಅವಾಗ ನೀವ್ ಹೇಳ್ದಂಗ ಆಗ್ಬೇಕು, ರಾಜಿ ಅಂತ ಆಗಲ್ಲ. ಗೆದ್ದಂಗ ಆಗಿದ್ರೆ ಸೋತಂಗ ಆಗುತ್ತೆ. ರಾಜಿ ಅಂದ್ರೆ ನೀವು ಸ್ವಲ್ಪ ಬಿಟ್ಕೊಡ್ಬೇಕು, ಅವ್ರು ಸ್ವಲ್ಪ ತಗೋಬೇಕು. ನಾನು ಹೇಳಿದೆ ಕರೆಕ್ಟು, ಅವ್ರು ಹೇಳಿದೆ ಕರೆಕ್ಟ್ ಅಂತಂದ್ರೆ ರಾಜಿ ಅಲ್ಲ ಅದು. ನೀವು ಆತರ ಅದು ಬಿಟ್ರೆ ಮಾತ್ರ ರಾಜಿ ಆಗ್ತೀನಿ ಅಂತ ಕಂಡೀಷನ್ಸ್ ಹಾಕಿದ್ರೆ ಇನ್ನು 30 ವರ್ಷ ನೀವು ಜಗಳ ಆಡ್ತಾನೆ ಇರ್ತೀರ. ನಾನೇನೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಬಿಡ್ತೀನಿ, ಇಲ್ಲೋ ಅಲ್ಲೋ ಎಲ್ಲೋ ಹೋಗುತ್ತೆ. 30 ವರ್ಷ ನೀವು ಅನುಭವಿಸ್ತೀರ. ನೀವು ರೆಡಿ ಅಂದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ, ಹಂಗೆ ತೊಂದ್ರೆ ಇಲ್ಲ. ಇಲ್ಲ ನಿಮ್ಮಷ್ಟು ನೀವೇ ಕೂತ್ಕೊಂಡು ಬುದ್ಧಿ ಬಂದು ಇತ್ಯರ್ಥ ಮಾಡ್ಕೊಂಡ್ರೆ ನಿಮ್ಗೆ ಎಲ್ಲರಿಗೂ ಒಳ್ಳೇದು. ಏನಾರ ಆಗ್ಲಾ? Then sit and settle. Why do you want to protest?
One of them is, that's why I never enter into a compromise, because I'm not able to solve everybody's problem. Giving a judgment is so much more easier for me. I don't want them to fight, and all of you are forcing me to render a judgment. Audio ready ಅಲ್ಲ, you'll have to sit and
because
I'm also ready for
ನಮ್ದೇನು ಪ್ರಾಬ್ಲಮ್ ಅವ್ರಿಗೆ ಏನಾಗಿದೆ ಪ್ಲೈಂಟಿಫ್ ಒಂದು ಶೇರ್ ಹೋಗುತ್ತೆ, ಅವರು ಎಲ್ಲ ಅರ್ಥದಲ್ಲಿ ನಿಲ್ಸ್ಕೊಟ್ಟಿರೋದು ಅಷ್ಟೇ. ನಾವು ವಿ ಆರ್ ರೆಡಿ ಟು ಗಿವ್ ದ ಶೇರ್ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಅಗ್ರೀಡ್ ಟು ದ
ask them to get them, send it to a mediator. We will settle it right here. Ask them to get the other 3 daughters or their children ಯಾರು ಕರ್ಕೊಂಡ್ ಬರಕ್ಕೆ ಬೇಡ, ಇಲ್ಲಿಗೆ ಬರ್ಲಿ, ಕರ್ಸಕ್ಕೆ ಫಿಕ್ಸ್ ಎ ಡೇಟ್. Get a date fixed, get everybody. But see that it is settled. Tell them the consequences. Supreme Court ಹೋದ್ರೆ ಒಬ್ಬೊಬ್ರು ಎಷ್ಟು ಲಕ್ಷ ಖರ್ಚು ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ 27th.
ಸಿಡಿ ವಿಜಯ್ ಬರ್ತಿದ್ದೀನಿ. I think 452 is concerned, that is the only thing which we are required to. So far as 13,469 of 2020, office was directed us to deposit the conference. Deposit. There is interest. Then you also asked us to recalculate it by taking into consideration the land as agriculture. According to this minute, they were entitled to 3 crore. Later minute, they have filed an affidavit saying that we don't want to cash compensation, we need to develop the. On the last occasion, also, how many numbers of sites they would be entitled to if the affidavit is considered. That I have secured instruction. As per the 50-50 ratio 3, the petitioner would be entitled to 21,370. Just narrated what has transpired and the page number 2 minute I will give. Paragraph number 7 minute.
Agreeable. Three, 462 is now complied with. Which was the order by which they agreed for sites 13,462?
This is the amount of 84,27,000. Just 2 sites, madam. Initially, madam, the deposited 66,71,005. 5/12/2022. 5/12/2022. 13,462.
13,12. You 7 lakhs ಮಾಡಬೇಕಿತ್ತಾ 7 lakhs you have to deposit.
I have already deposited. 6th of March. On 12/7/2022, WP 13462/2020 was disposed of. According the stand of the MUDA, that they would pay the compensation amount in terms of the 2013 Act. Subsequently, MUDA also filed a memo stating that a compensation of rupees 84,27,000 was to be paid, and one incentive site would also be allotted. By an order dated 15th of December 2022, MUDA agreed to allot 2 incentive sites as against the original offer of 1 incentive site. Today, it is submitted that MUDA has deposited a sum of rupees on
6th of March 2020.
And the MUDA is awaiting the correct dimension report in respect of the 2 incentive sites that it has agreed to allot to the petitioner.
Memorandum has already been issued on 6th.
Learned Council also submits that an official memorandum to this effect has already been issued. The copy has also been given to the petitioner. In view of the above, no further orders are necessary in WP 13462/2020 regarding allotment of sites. The petitioner is permitted to withdraw the amount rupees 7 lakhs so and so deposited before this court on 6th of March 2023. ಮುಗಿತಲ್ವಾ?
ಅದರಲ್ಲಿ ಅವರು ಸೈನ್ ಕೊಡೋದಕ್ಕೆ ಫರ್ದರ್ ಡೈರೆಕ್ಷನ್ ಕೇಳ್ತಿದ್ದಾರೆ. ಔಟ್ ಆಫ್
ಗಲಾಟೆ ಮಾಡೋಷ್ಟು ನಿಧಾನ ಆಗುತ್ತೆ. ಇಮೇಜ್ ಬಿಡಿ ಮಾಡ್ತಾರೆ ವಿವಾಕನ ಮಾಡಿ. ಎಷ್ಟು ದಿನ ಬೇಕು? Vivekananda submits that an allotment letter would be issued within a period of 2 weeks from today. The said statement is taken on record. 13/4/16/2020. The order sheet after the disposal is bigger than the order sheet before. So WP 13416/2020. This petition was disposed of on 12/7/2022 along with WP 13462/2020, directing MUDA to pay compensation in terms of the 2013 Act. Over thereafter, the petitioner submitted that as against the compensation, he would be prepared to accept compensation in terms of sites. Accordingly, an affidavit has been filed today by MUDA stating that the petitioner would be entitled to a total of 21,371 square feet in terms of 6 12/18-meter sites, 6 9/12-meter sites, and 1 6/9 meters site. ಎಷ್ಟು ದಿನ ಅಂತ ಹೇಳಿದ್ರೆ ಏನಾದ್ರು Council for MUDA, CTP Vivekananda submits that MUDA would allot the above mentioned 13 sites within a period of 4 weeks from today. In view of the said submission, the order dated 12/7/2022 is modified, and it is held that the petitioner would be entitled to 6 sites of 12/18 meters, 9/12, 6 sites of 9/12 meters, and 1 site of 6/9 meters, as per the memo filed by MUDA dated 13/3/2023.
462 ನಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. 469 ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು ಅಂತ.
That counsel for the petitioner submits that the documents of title regarding the lands that they own would be produced so as to facilitate MUDA in allotting the 13 sites mentioned above. Petitioners here. Now will you exclude one person?
Present requirement present before the court.
ಎಲ್ಲ ಹಾಕಿದಾರೆ affidavit ಓದ್ಸಲ ಹಾಕಿದಾರೆ. Date.
ಅವರು 30-40 ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಪ್ರಕಾರ ಹಾಕಿದ್ದೀನಲ್ಲ.
Date ಕೊಡಿ. Then where is the affidavit? ಇದರಲ್ಲಿ ಸೈಟ್ಸ್ ಬೇರೆ ಬೇರೆ ಆಗುತ್ತಲ್ಲ, ಇಲ್ಲಿ ಒಟ್ಟು 17 ಸೈಟ್.
40 4 ಸೈಟ್ ಅಂದ್ರೆ 30-40 4 ಸೈಟ್ not in favor of Bhagya number 1 same ಬರುತ್ತೆ ಮೇಡಮ್. One side 30-40.
Do one thing, you file an affidavit and ask him to act according to the affidavit.
This matter we have deposited 2,36,78,134. The amount paid to the order to
That comes to the petitioner submit that as per the earlier offer of 17 sites, the petitioners had agreed to apportion the site amongst Srimati Bhagya and Srimati Pavitra S. He submits that an additional affidavit will be filed indicating the manner in which the 13 sites that are now being offered should be apportioned. On such an affidavit being filed by the petitioners jointly, the MUDA will allot the sites in the manner suggested in the joint affidavit of the petitioners. The amount of rupees, the compensation amount deposited by MUDA before this writ petition shall be refunded to it.
please fill out the details of the bank account to transfer. Otherwise, I may not have
to the bank account of MUDA, an affidavit or a memo be filed indicating the details of the bank account to which the amount is required to be transferred. Keshav Prashant.
Keshav Prashant.
Liability nil dispute. 10% ಕೊಟ್ಟಿದ್ದಾರಾ? ಇಷ್ಟೇನಾ? ಇಂಜುರಿ ಎಷ್ಟು ದಿನ ಇದ್ರು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ? ಎಷ್ಟು ಕೊಡ್ಬೇಕು ನಿಮ್ ಪ್ರಕಾರ? 30,000. Respect of an accident which is not in dispute, and the liability of the insurer to pay the compensation is also not in dispute. The tribunal has awarded the following sums. The tribunal has taken note of the evidence of the doctor, which was to the effect that the claimant had suffered 10% disability to the whole body. In my view, this assessment of 10% of the whole body cannot be found forthwith and is therefore affirmed. However, the tribunal has determined the monthly income notionally at rupees 7,000, since there was no evidence to ascertain the actual income. My view, it would therefore be appropriate to adopt rupees 9,000, which has been assessed by KSLSA for an accident of the year 2015. Consequently, towards loss of future earnings, the claimant be entitled to some rupees 9,000 into 12. ಯಾವ multiplier? 13 into 10%. The tribunal has awarded a sum of rupees 30,000 towards pain and suffering. The evidence on record indicates that the claimant had suffered a crush injury to the left foot. 11. Apart from a laceration, the doctor who has given evidence has stated that the claimant was unable to keep his foot on the ground, that there were severe restrictions on ankle movement. In light of this evidence, it might be appropriate to award some rupees 75,000 towards pain and suffering. The tribunal has awarded some rupees 61,921 towards medical expenses. As this is based on documentary evidence, the same would have to be affirmed. The tribunal has awarded some rupees 2,250 towards conveyance, nourishment, attendant charges. In my view, it would be appropriate to enhance the said sum to rupees 10,000. The tribunal has taken the laid up period as 2 months. In my view, it would be appropriate to treat the laid up period as 4 months and award a sum of rupees 9,000 into 4. The tribunal has not awarded any sum towards loss of communities. As the claimant has suffered 10% disability to the whole body, it would be appropriate to award a sum of rupees 75,000 towards loss of communities. Consequently, 9,000.
My lord, I am for appellant, my lord. Is a case arise from the Workman Compensation Act. Only short question that can be considered is, my lord, the doctor has assessed the disability to the whole body as a 20.33%. Tribunal has considered 15%. Only on that count, my lord, since he is a driver by profession and injury sustained is fracture of both the bones, and there is a malunion. He underwent surgery. My lord, on that count, my lord, the disability aspect is to be revisited, my lord.
40.66% to the right lower, 20.33%
Page 7 ಅಲ್ಲಿ, page 7, the fracture ಅಲ್ಲಿಂದ ಪ್ಯಾರಾ 11 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ, ಅದು ಪ್ಯಾರಾ 11 ಅಲ್ಲೇ ಕಂಪ್ಲೀಟ್ ಬಂದಿದೆ. ಅವರು 1/3 ಮಾಡಿದ್ದಾರೆ. Since it is a case not under the Motor Vehicle Act, it is only I am entitled for compensation only for disability aspect, loss of earning capacity. Reduction to an extent of about 5%, more than 5% may is not permissible. Tribunal has not given any cogent reason why it should be 15%, only on the basis of calculation of 1/3.
ಎರಡು ಕಾಲ್ಗೂ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ.
ಹೌದು. Type 3 open fracture of right leg both the bones.
Right leg both bones.
Para 10 ನಲ್ಲಿ ಲಾಸ್ಟ್ 2 lines ಅಲ್ಲಿ ಇದೆ. Suffer type
20% ತಗೊಳ್ತೀನಿ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ. ಅದು
ಅಲ್ಲ, ಮೋಟರ್ ವೆಹಿಕಲ್ ಆಕ್ಟ್ ಆದ್ರೆ
ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ ಅವ್ರು ಮಾಡ್ಬೇಕು, ಮಾಡಿಲ್ಲ ಅದ್ರನ್ನ. ಮೈಲ್ಡ್ ಮ್ಯಾನ್ಯುಲ್ ಅಲ್ವಾ?
ಜಾಸ್ತಿ ಏನ್ ಬರೋದಿಲ್ಲ ಸರ್ ಅಷ್ಟೇ.
The tribunal could have determined the disability at 15% when the doctor had stated that the claimant workman had suffered a disability of 20.33% for the whole body. And as a consequence, what would be the loss of earning capacity? Would be the question that arises for consideration this appeal by the employee. The doctor who was examined has stated that the claimant had suffered a fracture of both the bones of the right leg, and he has gone on to assess the disability of 40.66% to the right lower limb and 20.33% to the whole body. The tribunal has taken 1/3 of the disability of the right lower limb of 40.66% and arrived at the figure of 15%. In my view, this assessment would not be the appropriate way to consider the loss of earning capacity. Admittedly, the claimant was working as a driver, and if a driver has suffered nearly 40% disability to his right lower limb, it would be obvious that there would be a definite loss of earning capacity. In my view, in the light of the medical evidence adduced, it would be appropriate to assess the loss of earning capacity at 20%. Accordingly, the claimant will be entitled to a sum of rupees 20% of 4,000.
197.606 is the relevant factor. Page number 14. One 177.
960 into 197.06. One lakh 89,177. The sum of rupees 10,000 award towards medical expenses is affirmed. ನೀವ್ಯಾರು? You are the employer.
ಅಲ್ಲೇ reading ಅಲ್ಲಿ
Your respond number 3 and 4. Your respondents 3 and 4. Chanbasappa and Dhananjaya.
Respond number 1 respond number 1 ಸಾರಾಳು ಇವರು ಕೆಲಸ ಕೊಟ್ಟಿರೋದು ಅಂತ ಹೇಳಿ ಅವ್ರ ರೀಡಿಂಗ್ ಅಲ್ಲಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ.
ಏನ್ ಕೆಲಸ?
ಇನ್ಸಿಡೆಂಟ್ ಏನಂದ್ರೆ ಇವರು ಅಪ್ಲೈನ್ಸ್ ಸಾರಾಮದು respond number 1 ಅಂತ ಹೇಳಿ
Timber.
Is the respondent number 1 there. And while putting on loading the timber, the rope was reading. But the payment period that respondent number 1 was interested in work to load and unload the timber. And he was paying 400 rupees per day and also 100 rupees expenses. And also, what important thing is that this incident, this respondent number, these appellants have heard their statement of objection and they have specifically contended that they do not have any land here is survey number 71/1. ಅದರಲ್ಲಿ ನಮ್ದು ಒಂದೇ ಅಲ್ಲ, ಬೇರೆ ಬೇರೆ ಲೋಡ್ ಮಾಡಲಿಕ್ಕೆ ಒಂದೇ incident took place in survey number 71/1. But I am not, these appellants are not the owners of.
What is your survey number?
My survey number is different. Intentionally not publicly actively showing survey number.
You admit that you had engaged that person to remove the timber?
Yes. I have entered into contact with the respondent number 1 to confirm the removal. Which I have told you.
Did you produce that agreement? And what is the finding of fact?
That is the survey number.
It's a finding of fact that you are the principal employer.
Yes, after that, but only on the basis of assumption. The criminal has possible liability.
For me to admit the appeal, there should be some substantial question of law. What is the substantial question of law here?
The criminal has not claimed that is easy for an employer and who is the employer. But simply the criminal has claimed issue number 2. Whether the criminal is entitled to compensation as but an issue.
This is not a original suit. This is not a original suit for issue to be framed.
Regarding that, what is the last? Employment and also the incident took place during the course of employment. ಇದರಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 14 ಅಲ್ಲಿ
EVRಗೆ yeah, principal employer ಅಂದ್ರೆ if they are agriculturists, if they had engaged you for some agriculture activities, principal employer ಬರುತ್ತೆ. If they have sold one part of the produce, you how can you be called how can they be called the principal employer?
But for having sold the timber, no proof is produced. They engaged the workers through an agent to cut and sell the tree. And it is admitted that the tree belongs to them. If they have produced any contract to show that I have sold the trees for this amount, and you can cut and remove by engaging your own workers.
No, for you to push forward this plea of principal employer, you admit that they are the principal employer. That is your claim. That is your contention. That's why you write them as respondents 3 and 4.
Yes.
Your case was respondent 1 and 2 were the contractors who have been engaged by respondents 3 and 4.
I'm only a worker.
Correct. If they are the principal employers, for the work that they normally do, if they extend it to somebody else, then they become principal employer. If they are two independent contracts, two independent avocations, how can they be principal employers?
They are not the principal employers as it means. See, this person entrusts the work to a person in the village. You please bring somebody, cut and take the timber. It is not a contract at all. See, he mobilized the workers, one of the workers mobilized this the claimant, and when the trees were cut and fell, this accident has happened. Therefore, the owner of the tree is responsible because they were doing his work. And the accident has happened during the course of the work in his premises.
No, if he has sold the timber, with the condition that you will remove it and take it, then where is the question of engaging him? He has sold the produce there.
Not sold. There is no evidence that he has sold. That's what I submitted, my lords. If he has sold the standing tree to X.
What was your averment in the claim petition as against them?
And even before this honorable court, their allegation is they are the owners of the tree and they take paramount proof of the facts of the case. They appear filed by this honorable court. Third line. Respondent number 2 and 4 were the owners of the trees which standing at the land.
No, you only submit, see, paragraph, page number 8, paragraph 2, it is submitted that on 19/5/2012, under the instruction of respondents 1 and 2, there was a contract for felling trees from the property of respondent 3 and 4. And when the petition was felling the trees from 1230 to so on.
Yes, contract means he had entrusted that work. It is not that the tree was sold and he entrusted that.
Let us see what is the meaning of a principal employer. What is the meaning of a principal employer?
This is not. As the contractor was supplying the contract laborers, the person who engages them through the contract.
Please read section 12. Well, one.
Contracting. Where person in the course of the purpose of this way or business, contract with any other person. Contract with any other person.
Execution by or under the contractor of the whole or any part of any work which is ordinarily part of the trade or business of the principal. So if it was his business to do felling of trees, and in that if he engages you, then he is the principal employer. Here it is a case of that person owning the agricultural land on which trees are grown. He sells the trees to somebody or
not sell. There is no evidence that he sold the trees and he asked me.
No, it is not your case that it was the primary trade of the third and fourth respondent of felling the trees, and that they had contracted that work to somebody. Therefore, they are principal employer. You are saying that they were the owners of the tree.
Yes.
Once you admit that, that means the principal business of these four respondents 3 and 4 was not the business of felling trees and selling it.
But he had engaged the contract workers to fell the tree through this contractor that is responding.
Yeah, the principal employer agala anta.
Principal employer and a prashna idralage baralla because there is no contract.
The tribunal has, the commission has relied upon that principle to make them liable. That's what it has said.
He has to pay because the work was done for him.
The principal employer concept barala idralli. Separate.
Principal employer concept idralage barodilla. That is what I am telling.
Hangidre, then you can't make him liable. You only have to go against response 1 and 2. The contractor what got the contract.
No,
for
it
filling
is
the trees.
contract in this. He told and he brought the laborers, he mobilized the laborers. Where is the contract? If he has produced any contract, if he has produced any contract before the court, that is a different matter. Contract means, see, village areas, do some work, they will interest, there will be a person who will mobilize workers into the field and carry out the work for the owner, whatever the work. It doesn't mean that it is a contract and he has sold.
ಎಷ್ಟಾಗತ್ತೆ ಅದು ಬೆಲೆ ಎಷ್ಟಾಗತ್ತೆ ಅದು ಮರ?
ಏನು ಕೊಟ್ಟಿಲ್ಲ 2010 ಅಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್, we are in 2023 and he has
ಡಿಪಾಸಿಟ್ ಮಾಡಿದಾರಾ?
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಇಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರಾಗ್ಲೇ ವಯಸ್ಸಾಯ್ತು, ಓಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಪಾಪ ಯಾರು ಕೊಡ್ಬೇಕು? ಸುಮ್ಮನೆ ಹೇಳ್ತಾನೆ ನಾನು ಓನ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟ್, ನಾನು ಮೊಬೈಲೈಸ್ ಮಾಡ್ತೀನಿ. ಇವರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
Need to accept the contention. The liability of interest also will continue. ಇದು ಮುಗಿದರ ಕೆಲಸ ಇದು. ಅವನು ಜಾಸ್ತಿ ಆಗುತ್ತೆ, ಅದಕ್ಕೆ ನಾನು
liability of,
see if I dismiss the appeal, they will have to continue to pay that interest from the date of the accident till the date of deposit. That way itself will be a huge sum. ಇದರಲ್ಲಿ ಕಾಜಿನ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇದರೊಳಗೆ actual facts ಅದು.
ನಾನು ಕಾನೂನಲ್ಲಿ ನನಗೆ ಪ್ರಿನ್ಸಿಪಲ್ ಎಂಪ್ಲಾಯರ್ ಅಂದ್ರೆ ತಪ್ಪು ಅನ್ಸ್ತಾ ಇದೆ. If I agree that it's a small amount, that liability of interest will be there.
Interest, my lords, reduce and
So the contract, the act does not permit any kind of reductions being made. Contracting out provision with it will be void. ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ?
72,000.
ಎಷ್ಟು? Injury ಏನಾಗಿರೋದು? Injury, what is the injury?
He was 53 years when the accident happened. Now he is 60.
ಮೂರ್ಗೇನ್ ಬರುತ್ತೆ ಕಾಸ್ಟ್ ರಿಮೈಂಡ್ ಮಾಡಿದ್ರೆ? You can also recover from them. You had engaged him. You only recover from them. Admit the appeal and keep it pending for another 5 years, that's all.
Like the 2017 appeal is coming up for admission in 2023. And it is their admission that it is their fee. And Workman the trial court has taken care of that, saying that merely because survey number mentioned is not, it can't be.
No, my difficulty I told you was that they can't be your principal employer. They are two different trades that they are doing.
There can't be principal employers.
If they are not the principal employer, you cannot make them liable. You only have to go against respondent 1 and 2.
Oh, because
They are the ones who engaged you, not them.
so engaged not under any contract. If there was a written contract, whether they sold the trees or not.
By your own standing, you say that respondent number 1 engaged you.
Yes, correct.
Now, therefore, prima facie from your own government, the employer is respondent number 1. You thereafter make R3 and R4 as parties only because they had in turn engaged R1. And they are therefore the principal employer, and that's why they've been made liable.
That arrangement is right as long as there is a contract. My pleadings may be there, but it cannot be taken as strict sense of contract labor arrangement in the absence of a contract. Here, nobody have produced that contract. Why he has made that arrangement is that he hired him. He took him to that garden to do this work, to whom the owner of the trees. There is no contract to say that the trees were sold to respondent 1 and 2. There is no document to show that there was a contract between respondent 1 and respondent 3 and 4. Therefore, it can't be inferred that he is not the principal employer. That concept doesn't apply in this case. This is only Halli Kade. Our Yara one Bavi Tegide on labor na mobilize.
Same petition government say is against you.
Yeah, so
ಅದೇನಕ್ಕೆ ತೊಂದರೆ ಆಗ್ತಾರೆ ಇಲ್ಲಾಂದ್ರೆ ಸುಮ್ಮನೆ
ಅದನ್ನ ಸ್ಟ್ರಿಕ್ಟ್ ಸೆನ್ಸ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂತ ತಗೋಬಾರ್ದು ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ.
ಎವಿಡೆನ್ಸ್ ಏನಾರು ಮಾಡಿದ್ರಾ ಯಾರು ನೀವು RW When was the incident? ಯಾವತ್ತು 1905. A known certificate alleged history of fall from tree ಅಂತ ಇದೆ. You admit that you had engaged that contractor on that particular day.
Particular date, yes, the date I have entered into an agreement regarding sale of trees. And he has stated that
ಕಿಶೋರ್ ಅಹಮದ್ ಇವರು ನನ್ನ ಸರ್ವೆ ನಂಬರ್ 74/4 ಜಮೀನಿನ ಮರಗಳ ಪರಿಚಯ ಮಾಡಿಸಿಕೊಟ್ಟಿದ್ದರಿಂದ ದಿನಾಂಕ 19/2/2012 ನನ್ನ ಮತ್ತು ನನ್ನ ಮಗನ ಅನುಪಸ್ಥಿತಿಯಲ್ಲಿ ತಮ್ಮ ಕೆಲಸಗಾರನ್ನು ಕರೆದುಕೊಂಡು ಬಂದು ಮರದ ಕಡಿತಲೆ ಮಾಡಿಸಿ ನಟವನ್ನು ಜಮೀನಿನಿಂದ ಸಾಗಿಸಿರುತ್ತಾರೆ. So you admit that you had engaged. ಪೊಲೀಸರು ಕಂಪ್ಲೇಂಟ್ ಏನ್ ಮಾಡಿದ್ರು?
ಅಲ್ಲೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
What is your reply to the legal notice? Did you give a reply? ಇದು ಕೊಟ್ಟಿಲ್ವ? ರಿಪ್ಲೈ ಕೊಟ್ಟಂಗಿಲ್ಲ ಅಲ್ವಾ? You received the notice and not given any reply. Reply ಕೊಟ್ರೇನ್ರಿ ನೀವು? And I'll hold it against you if you not given any reply. You admit the receipt of the legal notice. If you not given any reply, what is? ಕೊಟ್ಟಿಲ್ಲ ನೀವು ಹಂಗಾರೆ. No, but at the earliest point of time, if you are not given any reply, you are admitting the assertions. This appeal is by the employer contending that the compensation which is 72,000 awarded for the injuries suffered by the employee are not liable to be paid by the employer. It is the case of the appellant that he was the owner of land bearing number 71/4, 71/1 alva 1, and admittedly the incident took place in number 71/4, and therefore it cannot be held that you admit that it's a 71/1. That was your evidence.
ನಡೆದಿಲ್ಲ.
74/5, measuring 4 acres to 12 guntas. And the incident alleged to have occurred was in respect to number 71/1, and therefore it could not be held by the tribunal, by the commissioner, that the appellant was the principal employer. The commissioner on examination of the oral evidence has recorded a finding of fact that the fact that the appellants had engaged respondent number 1 and 2 for felling of trees was not in dispute, and therefore in law the appellants who were respondent number 3 and 4 were the principal employers and would therefore be liable. In other words, the commissioner has recorded a finding of fact that the appellants herein are the principal employers and they had engaged the first respondent for the purpose of felling trees, and the claimant who had been engaged by the first respondent and who suffered injuries would be entitled to be covered for compensation. In my view, the finding of fact recorded by the tribunal that the appellants were the principal employers and the claimant had been engaged through the contractor that they had employed cannot be found fault with. Essentially, since the claimant was engaged in cutting and felling the trees which were standing on the land of the appellants would be the employers and would therefore be liable for compensation. There is no submission of forest. The amount and deposit shall be made over to the claimant. Disability ಎಷ್ಟು ತಗೋಬೇಕು ಹೇಳಿ ಫಸ್ಟ್. ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ತಗೋಬೇಕು? ಅದರಲ್ಲಿ ಅವನ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ, ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಏನು ಇಲ್ವಲ್ಲ. ಕಾಂಪನ್ಸೇಷನ್ ಕಮ್ಮಿ ಆಗುತ್ತಲ್ಲ ಬಿಡಿ, 61 ವರ್ಷದಿಂದ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಕಮ್ಮಿ ಆಗುತ್ತಲ್ಲ, ಕಾಂಪನ್ಸೇಷನ್ ಕಮ್ಮಿ ಆಗುತ್ತಲ್ಲ. ಎಷ್ಟು ಏಜ್ಗೆ ಏನಿದೆ ಪ್ರೂಫ್? 61 ಅಂತ ಹೇಳಿದ.
1954 date of birth for 2003.
How old is he now?
Medical records ಅಲ್ಲಿ FIR ಅಲ್ಲಿ ಎಲ್ಲದರಲ್ಲೂ ಅವರು
1954, 46, 61, 61 years. ಎಷ್ಟು ಒಳ್ಳೆ ಡಿಸಬಿಲಿಟಿ ಹೇಳಿ? 75%. 75%. ವಯಸ್ಸಾದವ್ರಿಗೆ ಸ್ವಲ್ಪ ಸಿಂಪತಿ ಜಾಸ್ತಿ ಇರ್ಬೇಕು. Fact that an accident occurred 24/10/2015 is not in dispute, and as a result of the accident, the claimant suffered an amputation of his right leg below the knee is also not in dispute. The tribunal, on an assessment of the evidence, has awarded the following sums. In order to determine the loss of future income, the tribunal has assessed disability to the whole body. Though the doctor had assessed the disability to the right lower limb at 100%. In my view, since the claimant was aged about 61 years as on the date of the accident, as a result of an amputation below his right lower knee, it would have to be held that he has suffered a functional disability of 75%. The tribunal has taken the notional income of the claimant at rupees 6,000 per month. In view of the fact that the tribunal, that the case LSA has determined the sum of rupees 9,000 as the notional income for accidents of the year 2015, it would be appropriate to adopt the said income. So consequently, towards loss of future income, the claimant will be entitled to a sum of rupees 9,000 into 12 into 7 into 75%. The tribunal has awarded a sum of rupees 50,000 towards pain and suffering, and a sum of rupees 50,000 towards loss of amenities. In my view, in regard to the fact that the claimant had been hospitalized for 27 days, and he has suffered 100% disability to the right lower limb, it would be appropriate to award a sum of rupees 1 lakh towards pain and suffering and 1 lakh towards loss of amenities. The sum of rupees 2,29,350 awarded towards medical expenses, being based on documentary evidence, is affirmed. The tribunal has awarded a sum of rupees 20,000 towards food and nourishment and rupees 20,000 towards transportation charges. In my view, these sums are just and proper and do not require any enhancement. The tribunal has awarded a sum of rupees 5,400 towards attendant charges. In my view, having regard to the fact that the claimant has suffered an amputation and was hospitalized for 27 days, it would be appropriate to award a sum of rupees 30,000 towards attendant charges. The tribunal has determined the later period as 3 months. Since the income has now been assessed at rupees 9,000, the loss of income would be rupees 27,000. The tribunal has awarded some rupees 50,000 towards artificial limb. Then evidence is here. The doctor has stated that a sum of rupees 2 lakhs would be required. In my view, since there is no evidence indicating that the claimant had purchased an artificial limb, the sum of rupees 50,000 awarded would be just and proper. Consequently, the claim will be entitled to the following sums. Indian appeal.
50%
How did the accident occur?
alcohol.
Was under the influence of alcohol?
The percentage of alcohol is 153.
He was standing on the footpath.
And on the left side of the road, I came, the alcohol. They have also examined the RW.
Was charge sheeted. Charge sheet yaar ಮಾಡಿದ್ರು. ಮತ್ತೆ ಅವ್ರ ಮೇಲೆ 25% ಹೆಂಗಾಗುತ್ತೆ? I am with your favor.
Lord, the alcohol have examined my lord RW2. Second, my lord, 153.3, my lord, negligence.
Say, but did you examine the driver to show that he suddenly came in, he was drunk and he was not knowing? Okay, then on what basis did the tribunal say it's 25%? If I am drunk and standing in the road, is it negligence?
Not following the road, he is,
Crossing the road. What evidence is there to show that he was crossing the road?
sketch on the sketch on where exactly he is.
ಅವ್ರನ್ನ ಯಾರು ಎಕ್ಸಾಮ್ ನೋಡಕಲ್ಲ, ಅವ್ನು ಕುಡಿದು ತೂರಾಡ್ಕೊಂಡ್ ಬಂದ, ಸಡನ್ ಆಗಿ ಬಂದ್ಬಿಟ್ಟ, ಅವ್ನಿಗೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. The driver would have been the best person to talk about. There is no assumption that if you're drunk, you're negligent. How old was he? Their income?
There are accident 2015. That is the evidence. Five times more than allowed. 95.
The accident occurred in the middle of the road. Lorry driver would have been easily be able to see him. On cross ಮಾಡ್ತಾ ಇದ್ದ ಅಂತಂದ್ರೆ it take quite some time for him to cross when he's so drunk. You can easily see that person wobbling across. ನಾನು 100% ಮಾಡ್ತಿದ್ದೀನಿ. 100% ಮಾಡ್ತಾ ಇದ್ದೀನಿ. I am allowing his appeal. There's no evidence indicating that his drunkenness caused the accident. Contributory negligence means he contributed to the accident. Correct. The doctor says he cannot drive or walk properly. Yet the accident occurred in the middle of the road. If he cannot walk properly, if he has to walk across the road in his drunken state, the driver should easily be able to see him. And yet if he goes and hits him, he is drunk. What can you say about a drunk person? Your driver was not drunk. He could have seen that drunken man. He's a pedestrian. So you can go hit him if he's drunk. The argument hangge agbidutte. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್? The accident which occurred on 24/8/2015, which resulted in the death of Venkatesh, a 48-year-old, is not in dispute. The tribunal has awarded a sum of rupees 11,61,000 to the LRs of Venkatesh. The insurer is however in appeal, contending that the apportionment of negligence only to the extent of 25% on the deceased was inadequate. The claimants are also in appeal, contending that the attribution of negligence on the deceased to the extent of 25% was incorrect, and further the compensation awarded was also inadequate. The only argument advanced by the insurer is to the effect that the deceased had alcohol in excess of the legally permissible limits, and according to the doctor was examined, a person with the extent of alcohol found in the body of the deceased could neither drive properly nor walk properly. And since the deceased was trying to cross the road in such a drunken state, attribution of negligence to the extent of 25% was highly inadequate. Current counsel relies upon the judgment rendered by the High Court of Judicature of Madras in CMN number 747/2016 and contends that in similar case, the Madras High Court had fixed the liability at 50%. The evidence on record no doubt indicates that the deceased had alcohol, had consumed alcohol, and had 153.08 milligrams of alcohol. The doctor who was examined also stated that if a person has alcohol less than 32 milligrams, he can drive the vehicle properly. And since the learned counsel therefore contends that since the alcohol limit was 5 times the prescribed limit, it will have to be assumed that the deceased had contributed to the accident by crossing the road in his drunken state. In order to establish this contention that the deceased was crossing the road in a drunken state, there is no evidence at all. In fact, the best witness to talk about the contribution of the deceased to the accident would have been the driver of the lorry. However, the driver of the lorry has not been examined. The medical evidence on record indicates that the front left wheel of the lorry ran over the head of the deceased. This indicates that this does not indicate that the accident occurred when the claimant deceased was crossing the road. The fact that the impact occurred to the left wheel of the bus indicates that no such attempt was made to cross the road. So it may also be pertinent to state here that it is the driver of the lorry who had been charge sheeted. It is also to be noticed here that the driver of a lorry sits in an elevated position and would easily have a clear vision of the persons crossing the road. If the deceased had 153.08 mg of alcohol in his blood and could not walk properly, any attempt by him to have crossed the road in a drunken state could easily have been seen by the driver, and steps could have been taken to avoid the accident. In the light of this fact, it might have to be held that the driver of the lorry alone was responsible for the accident, and the attribution of 25% negligence on the deceased would be improper. The decision relied upon by the learned counsel to the Madras High Court would be of no avail, since it has been observed therein that when a person is under the influence of alcohol, the possibility of a rash and negligent driving gets aggravated would be a reality. However, in this case, it is not. In this case, admittedly, the deceased was not driving any vehicle in a drunken state, and he was only a pedestrian. Therefore, this decision rendered by the Madras High Court would be of no relevance to the present facts of the case. The appeal of the insurance company is therefore dismissed. As far as the compensation is concerned, the tribunal has determined the monthly income at rupees. There was no evidence to ascertain the actual income. In this view of the matter, the sum of rupees 9,000 determined by KSLSA for national year 2015 that we applied. The deceased was aged about 48 years. Hence, future prospects of 25% would have to be added. The said sum of rupees 9,000. The monthly income would therefore be rupees 7, out of which just 1/4, 1/4 would have to be deducted towards his personal expenditure, and as a result, the claimant should be entitled to some rupees also towards loss of dependence. The claimants being the wife and children, each one of them, wife, children, and parents, each one of them would be entitled to some rupees 44,000 towards loss of consumption and 33,000 towards under the convention. Also, modification of the interest awarded with the tribunal, the said sum shall carry interest rate of 6% per annum. DVR ಗೆ DM ಅಂದ್ರೆ ಏನು? DM ಅಂದ್ರೆ ಏನು? MVDM ಅಂದ್ರೆ mistake. Case of death. DM ಅಂತ. DM ಅಂತ. 2 lakhs ಕೊಟ್ಟಿದಾರಾ? ನೀವ್ ಯಾರಿಗೆ? ಪ್ರಾಪರ್ಟಿ ಓನರ್ಗ? ಹೆಂಗಾಯ್ತು ಆಕ್ಸಿಡೆಂಟ್? ಹೆಂಗಾಯ್ತು? ನೀವೆಷ್ಟು ಕೇಳಿದ್ದು? 8 lakhs ಕೇಳಿದ್ರು. ಮಾಡಿರೋರು 2 lakh 2 lakhs ಕೊಟ್ಟಿದಾರಾ? Paragraph ತೋರಿಸಿ. ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ 2 ಲಕ್ಷ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ನೀವು. ಏನಂತದೇನು ಏಟ್ ಆಗಿಲ್ವಲ್ರಿ ಫೋಟೋ ನೋಡಿದ್ರೆ. ಇಲ್ಲಿ ತೋರಿಸಿ ಫೋಟೋ ತೋರಿಸಿ. $2 lakhs ಸರಿ ಇದೆ ಅಂತ ಕಾಣ್ತದೆ. ಅದ ಕೊಟ್ಟಿದ್ರಲ್ಲ ನೋಡಿ, ನೀವೇ ನೋಡಿ ಸಮಾಧಾನ ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ಬರೀ ಒಂದು ಕ್ರ್ಯಾಕ್ ಆಗಿದೆ ಅಷ್ಟೇ. There's no evidence to that effect. You see the photograph, it does not indicate it's going to fall down. With 2.5 lakhs ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ. Yes. This appeal raises out of award by the tribunal, by which a sum of rupees 2 lakhs has been awarded for the damage caused to the house of the claimant. The evidence on record indicates that the excavator, which had been engaged for removing a tree, accidentally damaged the house. The tribunal taking into consideration the fact that the claimant had stated in his complaint initially that he had suffered a loss of rupees 2 lakhs, has awarded the sum of rupees 2 lakhs. The tribunal has refused to accept the assessment of PWT, the PW2, an AW of the PW department would assess the damage to the extent of rupees 22 lakhs on the ground that he had not even visited the house, and therefore reliance on his estimate cannot be accepted. A perusal of the photographs which are produced by the claimant, perusal of the photographs produced by the claimant does not indicate substantial damage to the entire structure. The photographs do indicate that there is some damage caused to the roof, and also there are some cracks in the wall. In my view, in respect of the damages as could be seen from the photographs, it will just end appropriate to award the sum of rupees 2,50,000 as against the sum of rupees 2 lakhs that is awarded by the tribunal. The appeal is thus allowed in part, and the sum of rupees 2,50,000 is awarded. Interest rate estimated. Interest rate 7%. Is a case about Sanmati. ಬರಲ್ಲ ಅಂದ್ರ ಅವರು ನೆಕ್ಸ್ಟ್ ವೀಕ್.
PO for respondent number 1, respondent number 2. in 46.1. My lords, I have not been served with the copy of the
Who are
appealing.
you?
I'm
the appeal?
the owner, my lords. Respondent number
Liability is under. But insurance company में क्या होता है? ये injury है ना?
Injury. Liability certificate.
Where is Ashok? Ashok ಒಂದು appeal ಇದೆ ಅಲ್ವಾ? ಅವ್ರದ್ದೇನು ground?
No. Exhibit B1 and exhibit B4, B14. They have produced another exhibit also. FIR. Suddenly, your name is shown as
Implanted, huh? Somebody was substituted as a driver.
all of you too know mitigation officer has been examined for
ಚಾರ್ಜ್ ಶೀಟ್ ಅವ್ರ ಮೇಲೆ ಹಾಕಿದ್ರಾ? ಟೈಮ್ಲೈನ್ ಏನಂತಾರೆ ಅದಕ್ಕೆ FIR ಆದ್ಮೇಲೆ? ಎರಡು FIR ಇದೆ.
ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು P1 and P14 ತಗೊಂಡಿದ್ದೀವಿ. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಕ್ಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಲ್ಲಿ very same day complaint.
But the sub-inspector denied exhibit R2. But the FIR which was submitted to the court did not have the FIR which was given to the court did not contain the name of the driver. What was the FIR that was sent to the court? What does that contain? That is Exhibit P1. Isn't it?
One which was sent there. It's hard to work on what we sent to the court. That is also the FIR.
Did you get this copy from the court?
Yeah, from the court. We got article was from the court. We got it among
P2 is not from the court. No, this is from the sub-inspector itself, not from the court. Which is the FIR which is registered and submitted to the court? Same crime number, huh? This is not received by the court. This is not received by the court. Exhibit R2. Only Exhibit P14 received FIR along with one document on 27/4/2015. How can you take cognizance of that? No, unless it is submitted to the court, then there is no point. He may have prepared many FIRs in the system office. Unless he has furnished it to the court, what significance would that have?
No. Right.
Oppose ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಉಮೇಶ್
Lords, I don't have any copies, my lords. I only serve with single copy. That's why I was.
Which case are you referring to?
Second, 660-6656, my lords.
That is over tomorrow.
Please, my lords. Next case.
Same, both of them together.
Please, my lords.
Umesh
Yes, ma'am. It's only on quantum. It's an accident pertaining to the year 2016. No evidence is produced to establish the income. He stated that he is an auto rickshaw driver. Tribunal has considered the income in the absence of any evidence as rupees 10,000. In fact, in illa ಏನು ಹಾಕಲಿಲ್ಲ.
ನೀವು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ?
ಯಾವುದು ಅಪೀಲ್ ಹಾಕಲಿಲ್ಲ.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ತಗೊಂಡಿದ್ದಾರಾ?
ತಗೊಂಡಿದ್ದಾರೆ. 40% ತಗೊಂಡು. ಪ್ಯಾರಾ ನಂಬರ್ 30 ಅಲ್ಲಿ in addition to that, 9% interest is awarded.
ಜಾಸ್ತಿ ಮಾಡ್ತೀನಿ ಬಿಡಿ ಹಂಗಾರೆ ಸಾಕು. ಕನ್ಸಾರ್ಷಿಯಮ್ ಆಮೇಲೆ ಇನ್ಕಮ್ ಏನಿದೆ ಪ್ರೂಫ್ ಹೇಳಿ.
ಇಲ್ಲ, ಪ್ಯಾರಾ ನಂಬರ್ 30.
ಏನು ಲೈಸೆನ್ಸ್ ಯಾವುದು? ಎಕ್ಸಿಬಿಟ್ 9. ಎಷ್ಟು ಜನ ಮಕ್ಕಳು?
Only mother. The other two are major siblings. Only mother. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲ್ ಹಾಕಲಿಲ್ಲ, 9% ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ. 9,500 ತಗೊಳ್ಬೇಕಿತ್ತು, ಇದರಲ್ಲಿ 10,000 ತಗೊಂಡಿದ್ದಾರೆ.
ಡ್ರೈವರ್ ಕಮ್ ಆಫೀಸ್ ಬಾಯ್. ಲೈಸೆನ್ಸ್ ಇದೆಯಾ? ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? P9 ಬರೀ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಮೇಲೆ ಇದೇನು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಲೈಸೆನ್ಸ್? ಏನ್ ಲೈಸೆನ್ಸ್?
ಆಟೋ ರಿಕ್ಷಾ ಡ್ರೈವಿಂಗ್.
ಎಲ್ಲಿದೆ ಅದು ಲೈಸೆನ್ಸ್ ಬಗ್ಗೆ?
LM ಇದೆ. Except conventional headings, there is no scope, because the tribunal has rightly considered the income as 10,000. Though in the year 2016, as per the guidelines,
being dissatisfied with the compensation is 15,42,000. Now the claimants are on appeal. In respect of an undisputed accident which resulted in the death of Hemant Kumar, a 24-year-old, the tribunal has awarded a sum of rupees 15,42,000 as compensation. In arriving at the said sum, the tribunal has assessed the monthly income at rupees 10,000 per month. In my view, with regard to the fact that the claimant had a driving license and KSLC itself had fixed 9,500 as the monthly income for accident year 2016, the sum of rupees 10,000 assessed by the tribunal cannot be found fault with. Consequently, the sums awarded towards loss of dependency are just and proper, since future prospects have also been added to it. However, the tribunal has committed an error in awarding only a sum of rupees 30,000 under the conventional heads. The claimants being the mother and siblings of the deceased, each of them will be entitled to 34,000, apart from the sum of rupees 33,000 under the conventional heads. And all the claimants will include the following sum at the same interest that is awarded with the tribunal.
ಅಲ್ಲ, ಇದರಲ್ಲಿ 6% ಮಾಡಿ ಸ್ವಾಮಿ.
ಬಿಡಿ,
ಅಲ್ಲ 9% ಕೊಟ್ಟಿದಾರಲ್ಲ ಅಲ್ಲಿ.
ನೀವು ಒಪ್ಕೊಂಡಿರೋದಕ್ಕೆ ನಾನು ಅದನ್ನೇ ಕನ್ಫರ್ಮ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ ಅಷ್ಟೇ. ಸುರೇಶ್, ರೇಣುಕಾ, ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಇದೆಯಾ? ಪ್ರೂಫ್ ಇದೆಯಾ? Yes. In respect of an undisputed accident, the tribunal has awarded the following compensation and made KSRTC liable to pay the same. The tribunal has taken note of
the medical evidence and has assessed the disability of the claimant at H percent, 28%, and has fixed and assessed the notional income at rupees 6,000. In my view, the assessment of disability at 28% cannot be found fault with since it is based on medical evidence. However, the assessment of the notional income at rupees 6,000 would be incorrect since KSLSA itself fixed rupees 8,500 as income for victims of motor vehicle accidents of the year 2014. Consequently, the claimant will be entitled to some rupees so and so towards loss of future income. The tribunal is awarded a sum of rupees 13,400 towards medical expenses. In my view, the said assessment, said award based on document evidence cannot be found fault with. The tribunal is awarded a sum of rupees 10,000 towards loss of immunities and rupees 75,000 towards pain and suffering. In my view, since the claimant has suffered 28% disability to the whole body, my view, since the claimant has suffered 9% disability, it would be appropriate to award a sum of rupees 75,000 towards loss of immunities and similar sum towards pain and suffering. The tribunal has awarded a sum of rupees 10,000 towards food nourishment, attendant and conveyance charges. In my view, since the claimant was hospitalized for 7 days, it would be appropriate to enhance the said sum to rupees 20,000. The tribunal has taken the later period as 15 days. Since the claimant has been assessed with having a disability of 9% to the whole body, and having regard to the fact that he was hospitalized for 7 days, it will be appropriate to determine the later period as 3 months. And consequently, the claimant will entitled to some rupees so and so towards loss of income in the later period. It's a consequence of claim for themselves. $10,000. Or appeal hai na? Future prospects ಕೊಟ್ಟಿದ್ದಾರಾ? ಕೊಟ್ಟಿದ್ದಾರಾ? Claimants ಯಾರು? ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಅವ್ರ ಪ್ರಕಾರ ಇನ್ಕಮ್ ಏನು ಅವನೇನ್ ಮಾಡ್ತಿದ್ದ? His number?
Compute the compensation necessary based on need, not on need. But what part of the needed is on the vehicle tax and vehicle tax. Standard of living, cost of living is the relevant one.
$30,000 ಮಾಡಿ 50% ಮಾಡ್ಬೇಕಾ?
30% enhanced, 50% direct. Multiplier of 18 is
2015 accident.
Plus the nature of the injury. 48 was there.
44, 44. 4 ಜನ ಇರೋದೆ
Siblings.
ಎಲ್ಲರಿಗೂ ಬರುತ್ತಲ್ಲ, ಎಲ್ಲರಿಗೂ ಬರುತ್ತೆ. ಮೂಮೆಂಟ್ ಆಫ್ ಆಕ್ಷನ್ ಎಲ್ಲರಿಗೂ ಇರುತ್ತಲ್ಲ, ಬರೀ ಅಪ್ಪ ಅಮ್ಮಂಗ್ ಮಾತ್ರ ಇರುತ್ತಾ? Respect of an accident which is not in dispute, and liability of the insurer to pay the company is also not in dispute. The tribunal has awarded a sum of rupees 16,39,200. The insurer as well as the claimants are on appeal. The insurer contends that the sums awarded is excessive. It is also contended that the deceased being a bachelor, 50% of the notional income should have been deducted, whereas only 1/3 has been deducted. Claimants on the other hand contends that the monthly income of rupees 8,000 assessed with the tribunal is inadequate. It is contended even according to KSLSA, the monthly income should be rupees 9,000. It is also contended that the claimants being the parents and siblings, each of them will be entitled to loss of love and affection. As stated above, the fact that the accident occurred resulting in the death of Sharat, a 19-year-old, is not in dispute. The tribunal has assessed the monthly income notionally at rupees 8,000, since there was no evidence to ascertain the actual income. Since KSLSC has determined the monthly income at rupees 9,000 for accidents of the year 2015, it would be appropriate to adopt the said income. And to the said income, 40% is required to be added as future prospects. Since the deceased was a bachelor, 50% of the said amount will be deducted towards his personal expenditure. And as a result, his monthly income for the purpose of calculating the loss of dependency would be rupees so and so. The claimant should therefore be entitled to some rupees so and so towards loss of dependency. The tribunal has awarded a sum of rupees 30,000 under the conventional rates. Since the claimants are the parents and siblings of the deceased, each of them would be entitled to some rupees 44,000 towards loss of love and affection. They would also be entitled to some rupees 33,000 under the conventional rates. Medical expenses anyway. Consequently, the appeals are disposed of, modifying the award of the tribunal to the extent stated above, 6%. Delay control, order sheet. 50.1.
There are two appeals made under this. Made claiming to the other baby. Two made claiming.
One by the owner. This first time appeal is by whom? To 30 to 41. ನೀವೇನ್ ಮಾಡ್ತಿದ್ರೆ? ಇನ್ಶೂರೆನ್ಸ್ ಇರ್ಲಿಲ್ವಾ? Next week.
Front injury of even tenderness instead of the other injuries may not.
ಏನಕ್ಕೆ? Among 35% disability. Paragraph. Ten percent ಸರಿ ಇದೆ ಅಲ್ವಾ? 10% ಸರಿ ಇದೆ. ಅಲ್ಲ ಏನಕ್ಕೆ ಏನು ಏನಕ್ಕೆ ಡಿಸಬಿಲಿಟಿ ಏನಾಗಿದೆ ಅಂತ? ಇಂಜುರಿ ಹೇಳಿದ್ದು ಬರೀ ಅಬ್ಡಮನ್ಗೆ ಏಟ್ ಆಗಿದೆ ಅಂತ. ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿಲ್ವಾ? $10% 1 ಲಕ್ಷ ಮಾಡಿದಾರಾ? ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಎಷ್ಟು? $1 ಲಕ್ಷ ಸರಿ ಇದೆ, ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟಿದೆ ಯಾವ್ದಿದೆ? ಏನ್ ಡಿಸಬಿಲಿಟಿ ಏನು ಬರೋದಿಲ್ಲ ಸರ್ಟಿಫಿಕೇಟ್. 30 to 35% ಡಿಸಬಿಲಿಟಿ ಟು ವಾಟ್ ಅಂತಾನು ಬರ್ದಿಲ್ಲ.
charges any particular like.
Tribunal has awarded sum of rupees 1 lakh as compensation and rupees 39,462 towards medical expenses. The claimant being dissatisfied with the said amount is an appeal. Third counsel contends that the doctor stated that the claimant had suffered disability to extent 30 to 35%, and therefore, according to the judgment of the Supreme Court in Mallikarjun's case, sum of rupees 3 lakhs ought to have been awarded. It is also contended that no sum has been awarded towards conveyance, food, nutrition, and attendance charges, though the claimant was hospitalized for 30 days. In my view, though the doctor has issued a disability certificate stating that the claimant has suffered 30 to 35% disability, it is not specified as to what was the disability that the claimant actually suffered from. Since the claimant has suffered an injury to the liver, the question of any permanent disability would not arise unless there is specific medical evidence to that effect. In that view of the matter, the assessment at 10% and award rupees 1 lakh cannot be found fault. The tribunal has also awarded a sum of rupees 39,462 towards medical expenses. And since this is based on documentary evidence, the same will be affirmed. The tribunal has, however, not awarded any sum towards food, nutrition, and attendance charges, though the claimant was hospitalized for 30 days. In my view, it would be appropriate to award a sum of rupees 30,000 towards food, nutrition, and attendance charges. Consequently, the claimant needed the following sum. Next week.
Problem. May during matters next week, my lord?
Yes.
Problem.